All rise, come to order. Thank you. Please be seated. All right, thank you, everyone. I appreciate you adjusting your schedules for the court. Couple preliminary matters before we get down to sentencing. One, under Georgia law, whenever you tender something, especially a video or an audio, it needs to be done in triplicate. I don't hold y'all to that standard during trial because I understand that y'all are busy. That being said, I'm going to order the lawyers to confer with the court reporter within the next 10 business days regarding the exhibit list. Obviously, we all know what it is, but she's going to final form that, and I want to make sure that we're all set as far as copies and all those types of things. No one's in trouble, just want to be clear on that. I'm going to do this now versus after the end of pronouncement of sentencing, and it's no reflection of what sentencing will or will not be. But it's a post-conviction scheduling order pursuant to Uniform Rule 41. If a motion for new trial is filed, the court reporter shall file the transcript of the trial no later than September 8th, 2026. No disrespect to the court reporter, I imagine that with the 2-week length of the trial, that may be longer, but that's what we're going to start with. The court shall be notified by the court reporter, and also the parties shall be notified when the transcript is filed. Any request for extension of the deadline by the court reporter must be done by the court in writing. I will accept email to the parties as well. Obviously, the defense usually drives that chain of events, so I'll let you coordinate, obviously. Hearing for motion for new trial, if one is filed, shall be held 1:30 p.m. on October 29th, 2026. Again, that's subject to the transcript. Again, due to the length of the trial, I anticipate it's going to be a little bit longer. All right, thank y'all. We have the state. We are here for sentencing. The jury's verdict speaks the truth. The jury has found defendant guilty of various charges. We'll hear from the state in aggravation, and then the defense in mitigation. Victim impact will be on the state side during your aggravation portion of presentment. Any questions?
Judge, I think we're going to, because of the Georgia Survivor Justice Act, we're going to present first, if it please the court, and then the state's going to go after we make our presentation.
Yes, Judge, I discussed with Mr. Willis beforehand, since they have the burden by preponderance for the Survivor Justice Act. I believe it would be appropriate for them to present evidence as to that first, and then the state is prepared to present evidence in rebuttal to the defense's evidence.
Court has no objection. Proceed when ready.
We'll call Dr. Andrea Elkon. Judge, can I get the Elmo overhead?
Emma or laptop?
Elmo.
All right.
Thank you.
All right. Good morning. Do you swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you so much. Please seated. Please speak into the microphone.
Please state your name for the record.
Andrea, A-N-D-R-E-A, last name Elkon, E-L-K-O-N.
And you previously testified at the trial and were offered as an expert, but I'm going to just go ahead and re-offer you, okay?
Yes.
What is your profession?
I'm a clinical psychologist.
And what is your educational background?
I completed a Bachelor of Arts degree with a major in psychology. I have both a master's degree and a PhD in clinical psychology. As part of a PhD, I had to complete both a predoctoral and postdoctoral training in the field of forensic psychology specifically. Been in practice for 20 years now.
And has your practice included forensic psychological evaluations?
It has.
How many forensic psychological evaluations have you conducted over the course of your career?
I would approximate over 5,000.
What does a forensic evaluation mean? And again, we've already gone over this some, but just briefly orient the court about what that means.
So forensic psychological evaluation is whenever there is an issue of mental health that crosses with a legal question.
And are you licensed in this state?
Yes.
Have you been tendered and accepted as an expert in Georgia state courts?
Yes.
And how many times approximately?
In Georgia state courts, I would estimate over 100 times.
And have you been tendered and accepted as an expert in forensic psychiatry or psychology in federal courts?
I have.
You said you'd done a number of forensic psychological evaluations. Have those evaluations also intertwined with PTSD evaluations?
Yes.
And have they also involved intimate partner violence?
Yes.
About how many evaluations that you have conducted have involved PTSD or intimate partner violence?
Of the 5,000, I would estimate that between a half and a third involved PTSD.
So somewhere around 2,500 to, I don't know what a third of 5,000 is.
Yes.
2,000, 3.
Somewhere between, yes, 1,500 and 2,500.
Judge will offer Dr. Elkon again as an expert in forensic psychology and intimate partner violence.
No objection.
So ordered.
Did you conduct a psychological assessment of Ms. Mericle in this case?
Yes.
May I approach the witness, Judge?
Yes.
Showing you what's marked Defendants 1. Is this your evaluation that you conducted in this case?
Yes, it is.
In connection with Defendants 1, did you, did you interview the defendant?
Yes, I did.
And did you do what's called collateral investigations and interviews as well?
Yes.
Okay. And since that initial interview, have you also looked at additional material after the sentence, after the trial?
Yes, I have.
Okay. Let me approach the witness, Judge, and show you what's marked as 2, Defendants 2, Defendants 3, Defendants 4, 2, 3, 4, and 5, and 6.
Any objection?
No objection.
So 2, 3, 4, 5, and 6, just show me those.
The presented exhibits are admitted.
Have you reviewed those?
I have reviewed all of them.
What is defendants 2?
Defendant 2 is Birmingham Police Department arrest report.
Okay. And that relates to the arrest for Terry Hagan, which we'll talk about in just a second. What is defendants 3?
Defendants 3 is text messages between Ms. Mericle and the decedent, Mr. Barron, and it includes photos.
And what is defendants 4?
Defendant 4 is the transcript of an interview with Jessica Sellers.
And what is defendants 5?
Defendants 5 is family violence ex parte protective order with Suzanne Mericle as the petitioner and James Terry Hagan as the respondent.
And what is defendants 6?
Defendant 6 is a family violence domestic relations case filing information form. This reflects a protective order filed by Alina Sokolansky against James Barron.
And Judge, I think you already admitted 2 through 6. I'm also going to tender 1, which is Dr. Elkon's report.
Any issues with 1?
No, Your Honor.
All admitted.
When you conducted the interview of Ms. Mericle, did you try to determine evidence of family of origin, violence, or trauma in her life?
I did.
Okay. Who did you speak to, in addition to Ms. Mericle, in connection with drawing a conclusion about that?
I interviewed 2 of her sisters.
And what did you learn about Suzanne's early life in relationship to child abuse specifically and trauma in the home?
I learned that for a brief time during early childhood, Ms. Mericle had a stepfather, and there was a lot of arguing and fighting, drinking, with the stepfather perpetrating violence against her mother and against her brother that she witnessed.
And this was corroborated by speaking with her 2 sisters as well?
Well, one of her sisters, the other sister wasn't old enough to.
She was a small child?
Correct.
Got it. So there's alcoholism in the home?
Yes.
Specifically, what did the stepfather do that Suzanne was either a victim of or witnessed?
Suzanne reported that she witnessed her stepfather beating up her brother and kicking the rest of them.
Physically striking them by foot? In
Yes.
other words. Did she relate to you about what it was like in the home with the stepfather? Was the mother present? In other words, was the mother at home when all this was happening?
The way that the family that I interviewed, Suzanne included, described the household was that mom was, for most of her life, a single mom and working all of the time. And so the children essentially raised each other.
And that would include Suzanne raising her younger siblings?
Correct.
And being raised by her older siblings?
That's correct.
What is that fact or that history? What's the relationship of that to maybe somebody having trauma later in life?
Well, I think the important part from the childhood trauma is that it establishes very little modeling about healthy partnerships. That not only was Suzanne witnessing domestic violence between 2 partners, but also just didn't have a good sense of what it meant to be in a healthy relationship.
Did you speak to Suzanne and also conduct collateral investigation related to Suzanne's relationship with various male partners throughout her life.
I did.
Can you tell us about her first marriage to a gentleman named Pete?
So the way that Ms. Mericle described her first marriage was that he was controlling, emotionally abusive, would call her a lot of bad names, put her down a lot, was very not in favor of her working as hard as she did.
And what was the ultimate cause of the end of that marriage, according to your investigation?
I believe it was infidelity that ended the marriage.
On whose part?
On Pete's part, on her ex-husband's part.
I want to move forward and talk to you about her marriage to a gentleman named Kevin Haley.
Yes.
What did you learn about her relationship in this marriage to Kevin Haley, which I think was 2011 to 2018, is that right?
Yes, that's correct.
What did you learn about their relationship?
Well, this relationship, the way that Ms. Mericle initially described it was that he just really wanted her for her money, that her sisters reported that he was actually sexually coercive, demeaning of her, wanted her to, according to her sister, Kevin wanted her to bring in another party into their relationship, was encouraging her, maybe coercing her to have plastic surgery. Yes.
And the bringing another party into the relationship, that was another female that he was trying to get involved in the relationship?
Yes.
Did Ms. Mericle have plastic surgery in response to Mr. Haley's requests on her breast specifically?
I believe so.
Did you learn anything about violence that was witnessed by any of the children by Mr. Haley towards Ms. Mericle during that marriage?
I did.
And who was it that had witnessed the violence by Mr. Haley towards Ms. Mericle?
Her son, Mills.
What was the violence that Mills witnessed with respect to Kevin Haley and Ms. Mericle?
It's my understanding that Mills witnessed Ms. Mericle and Mr. Haley fighting, that Mr. Haley shoved Ms. Mericle and Mills tried to intervene, and then Mr. Haley shoved him.
Moving forward to her relationship with Mr. Terry Hagan, is that a name you're familiar with?
Yes.
May I approach, Judge? I'm going to show you Defendant's Exhibit 2. This is the Birmingham Police Report from September 4th of 2023. Is that part, you already said you'd already reviewed that, but just to confirm, that's something you reviewed?
Yes, it is.
Can you flip to the tabbed part of that and take a look at the highlighted portion and just read for us what occurred in that police report?
Yes. A guest on the third floor had called the front desk and stated that they heard fighting coming from a room next door. The hotel's security guard went upstairs, but the couple in room 301 refused to answer the door. 911 also received a call from another room at the hotel stating that he could hear fighting coming from the room next to him.
And I think there's a further line about her injury.
Yes. Mericle stated that Hagan began cursing and yelling at her. She stated that Hagan slapped her in the face and grabbed her left wrist when she attempted to defend herself. Officer observed bruising to Mericle's right wrist and a scratch mark to the center of her chin.
And is it your understanding that Mr. Hagan was arrested and charged with that assault?
I am.
Showing you Defendants 3. This is the text message between Mr. Barron and Ms. Mericle that you previously identified.
Yes.
And could you read the top of that text message, the message that Ms. Mericle sent to Mr. Barron, and the date?
The date,
It's probably at the bottom.
Yes, sorry. The date is 1/20/25. The text is, after he beat me up, he told me the same thing you do because you deserve it.
Can I have that from you? I'm going to put this on the forehead. In this message, Ms. Mericle included 3 photographs,
Yes,
correct? One is of a wrist injury, one's of a facial injury, and one is of I guess, the right shoulder.
yes, that's correct.
And did these photographs on the next page, these are sort of the blow-ups of those photos, is that right?
That's correct.
Did you find any corroboration for the violence that occurred between Mr. Hagan and Ms. Mericle, other than the things we're going to talk about in a minute, which is the TPO and the photos and things like that? Any other witnesses, I guess, of corroboration of the violence?
Yes, so both of Ms. Mericle's sisters are familiar with Mr. Hagan personally. Both referred to him as not a nice guy. Both referred to him as a known abuser.
And specifically showing you defendants 4,
Yes,
the interview with Jess Sellers.
yes.
What in the interview with Jess Sellers, well, first of all, what date was the interview of Jess Sellers? I think it's at the top of the interview.
April 1st, 2025.
Okay. And Jess Sellers was a friend of Ms. Mericle's?
I believe that, yes, a friend and Ms. Sellers referred to Ms. Mericle as a second mom. I believe that Ms. Sellers worked for Ms. Mericle.
Can you tell us about some of the corroboration that you see in the interview with Ms. Sellers about the violence that Ms. Mericle suffered at the hands of Mr. Hagan?
Yes, Ms. Sellers directly observed Ms. Mericle coming into work, and she was beaten black and blue, I believe are Ms. Sellers' words.
Were there other things in Ms. Sellers' interview that you found interesting in relationship to intimate partner violence?
Yes.
Can you tell us about those?
Yes, so Ms. Sellers and Ms. Mericle seemed to talk fairly frequently during the time shortly after she had broken up with Mr. Hagan and when she was together with Mr. Barron. It seems as though Ms. Mericle confided in Ms. Sellers about the things that had gone on with Mr. Hagan, as well as the way that Mr. Barron was treating her. What I thought was noteworthy was that Ms. Mericle was adamant that she didn't really want to talk about it or for anyone to know, which is very consistent with somebody who was being abused.
Would it be unusual for a person who's in an abusive relationship to be telling everyone about the abuse? Would that be an unusual behavior?
It would.
What is the normal behavior for someone who's suffering violence at the hands of someone else?
Typically, someone who's in a domestically violent partnership doesn't tell because of the shame associated with it.
Ms. Sellers had actually, I think you said, witnessed and seen the actual injuries on Ms. Mericle that were visited upon her by Mr. Hagan. Is that right?
That's correct.
I'm going to show you Defendant's Exhibit 5, which you previously identified as the temporary protective order that Ms. Mericle sought and was granted against Mr. Hagan. Can you take a look at the highlighted portion and tell us what we see there? And if you want to read it, you can.
Sure. Respondent pushed petitioner against the wall and punched her multiple times in the stomach. Respondent broke her hearing aids by slamming her head in his refrigerator multiple times. Respondent knocked her down and drug her across the floor, causing great bruising. Respondent also put his hands on her throat, but she did not lose consciousness. Respondent further slammed her foot in the door.
And that was one incident. That's the,
That, I believe, was the August 2024 incident.
okay, so there are sort of two, I guess, incidents relating to Mr. Hagan. One is from September 2023, which we talked about. That's the Birmingham one, is that right?
Yes,
Okay, and then there was an August 2024, which resulted in the seeking of this TPO.
that's correct.
I think that, can you talk about the lower part on the TPO, the other incident? I think they're relating back maybe to the other one.
Yes, so the second, or this, it was actually the first incident chronologically, Labor Day weekend 2023, state of Alabama. Petitioner and respondent were in a hotel room when he became abusive. Concerned patrons called the police as he was verbally and physically assaulting petitioner. Respondent grabbed her by her hair, threw her down, strangled her, and kicked her. He was arrested by police for domestic violence charges. Petitioner had visible bruises when law enforcement arrived.
I want to show you just some of the attachments to that. Well, before I do that, at the back of the temporary protective order, do you see what this material is here that's tabbed?
I do.
And what is that?
That appears to be a hospital record.
Where Ms. Mericle sought medical treatment?
Yes, for assault, closed head injury, and musculoskeletal pain.
And does it relate the date that she sought the medical treatment in that record?
Yes, that's 8/7/2024.
And I think maybe it says related to an assault that took place at a certain date.
Correct. Patient presents to the emergency department, states that she was assaulted by a partner 2 days ago.
Thank you. Would you agree there's probably about 30 photos attached to this?
Yes, I would.
And some of these we've seen already, but did Ms. Mericle state in one of the materials about having a wrist stomped on by Mr. Hagan? Remember that?
Yes.
Are the injuries in Defendant's Exhibit 5 consistent with intimate partner violence?
Yes.
Is the seeking of the TPO also something that's consistent with intimate partner violence?
Yes.
And Defendant's 6, which was previously tendered, the TPO that was sought by Ms. Sokoliansky,
Yes.
what is the connection, if any, to intimate partner violence the fact that Mr. Barron previously had a TPO sought against him?
Well, I think this offers evidence that he was scary and threatening, not just to Ms. Mericle, but that he had a history of behaving in that manner.
Do people who have committed intimate partner violence typically do that again?
Yes.
Is it likely that a person who's committed intimate partner violence is going to just stop doing that sort of thing later on in their life?
It's highly unlikely. To the contrary, typically the violence escalates over time.
Talk to me about the relationship. Well, let me circle back and talk about the PTSD diagnosis that you previously offered, okay?
Yes.
That's already in the record, and the court's already heard evidence about that. But just to reorient us, did you do an examination of Ms. Mericle to determine if she suffered from post-traumatic stress disorder?
I did.
And what was your conclusion?
My conclusion was that Ms. Mericle does suffer from post-traumatic stress disorder, which I characterized as chronic.
Chronic, and I think you said severe as well.
And severe, correct.
What's the difference between chronic, severe, and I guess what are the other types of diagnoses you can make on a PTSD examination?
So the chronicity has to do with the length of time that the symptoms have persisted. So if symptoms persist more than a 6-month period, the condition is considered chronic. The severity has to do with two things, really: the amount of distress that the symptoms cause the person who is experiencing them, and the extent to which those symptoms disrupt functioning.
Okay. Are there such things as mild cases of PTSD?
There are.
Are there such cases of moderate post-traumatic stress disorder?
That's correct.
Okay. And Ms. Mericle's is severe?
That's correct.
What is the relationship between the history, Ms. Mericle's history that we've outlined here, and a post-traumatic stressor like the one related to the March 7th, March 8th, 2025 event?
Well, what we see over the course of Ms. Mericle's life is a repetitive pattern of getting into relationships with coercive and controlling men, and the extent to which they coerce and control appears to escalate over time to the point at which it becomes violent. And the more that Ms. Mericle was in these coercive, controlling, and ultimately abusive relationships, the more that, as I've testified previously, the more that a person's fight or flight mechanism stays switched on. And it's once that switch is permanently on that someone develops PTSD.
Is someone more likely to develop PTSD if they've suffered traumatic experiences throughout their life?
That's correct.
Does the literature and your profession support that conclusion?
It does.
In other words, if there are two persons and the same event happens to those same people, to those two different people.
Yes.
Okay. One of them has a history of abuse and the other one does not. What does the literature and the science tell you about the likelihood of developing post-traumatic stress disorder?
The person who has experienced the lifetime of trauma, that person is more likely to develop PTSD than someone who hasn't.
Okay. Talk to me about vulnerability. I think you have some, but talk to me about someone's vulnerability, specifically Suzanne's, in relation to intimate partner violence with the history that she has.
Ms. Mericle was extremely vulnerable to getting into relationships with controlling, coercive, and abusive men. She was much more vulnerable to getting into a relationship in which intimate partner violence was present.
And I already asked you this again, but I'm going to ask you again. Was Suzanne, in your opinion, subjected to family violence or dating violence and child abuse?
Yes.
You realize that the jury convicted her of a reckless act of firing a gun.
I do.
I want to talk specifically about reckless behavior.
Yes.
In relationship to someone with this background, of childhood trauma, family violence, and dating violence?
Yes.
Okay. What is the relationship with that trauma towards specifically reckless behavior?
Sure. So when somebody, again, I'm going back to this idea of a fight or flight switch kind of permanently switched on, it results in a symptom that we call hypervigilance, which means that someone is just more likely to react, more likely that if they sense danger, it's a quicker response and a more reckless response. And so as part of that hypervigilance, reckless behavior is actually symptomatic of PTSD. So it's all kind of encapsulated in that hypervigilance symptom.
And specifically with respect to the DSM-5, I guess we're on now, right?
Yes, 5TR.
5TR, okay. With respect to the DSM, what does the DSM say about reckless behavior in persons who have PTSD?
So as listed in the DSM-5, irritable behavior and angry outbursts expressed as verbal or physical aggression toward people or objects.
And does it endorse that reckless behavior is something that a person will be more likely to engage in if they have PTSD and a history of violence?
Yes.
I want to talk to you about your conclusion with respect to whether or not this history of violence, the history of violence that you saw involving the child abuse, the family violence, and the dating violence, in addition with the PTSD, okay?
Yes.
Specifically, whether all of those things were or can be said to be a significant contributing factor to the offense here, which would be a reckless offense.
They absolutely can.
Now, significant, I want to talk about what significant contributing factor means. Okay?
Sure.
Does significant contributing factor, from a psychological perspective, does it mean cause?
No.
Does it mean that it rises to the level of justifying the defendant's conduct under the law?
It does not.
Does it mean the exclusive or even the overriding factor?
It does not.
Does it instead mean it's something sufficiently significant to have likely helped bring about the defendant's behavior?
Yes.
And are you of the conclusion that this history and her past trauma is sufficiently significant to have likely helped bring about the defendant's criminal behavior?
It is.
I want to talk to you just about two more things before I let you go, okay? Did you do an assessment related to Ms. Mericle, a psychological assessment, to test for things like future dangerousness?
I did.
Can you tell the court what you did and what your conclusions were?
Yes. So I completed a test called the psychopathy checklist. This is what we call a semi-structured clinical interview. So what that means is that there are kind of guideline questions, but I can adjust a little bit, as well as, so this test includes the semi-structured interview plus a review of collateral data. And what this test does is it scores someone, it assesses the extent to which a person manifests personality traits consistent with psychopathy. And what we know is that there's a strong correlation between high levels of psychopathy and high levels of violence. In Ms. Mericle's case, she scored a 5 out of 20, which is consistent with very low levels of psychopathic personality traits and therefore a very low risk of future violence.
As far as then future dangerousness from a psychological perspective,
Yes.
How does she score?
I do not opine, based on testing, I do not opine her to be a risk of instigating future violence.
Is she a candidate for rehabilitation, specifically related, obviously, to PTSD and things like that?
I think Ms. Mericle would deeply benefit from therapy for PTSD.
Thank you.
Dr. Elkhorn.
Good morning.
As far as the work that you did to be able to get to the opinion you stated about this defendant, I want to go through a couple things, okay? Did you reach out to Alina Sokoliansky and interview her as part of your work on this case?
I did not.
You did not find it would be important to interview somebody who had taken out a TPO or attempted to take out a TPO against Mr. Barron in this case?
I thought the TPO and the information contained in the TPO was sufficient.
And in fact, in the TPO, Ms. Sokoliansky states that she took out a petition to get a TPO because Mr. Barron burned yard waste very close to the house while he was intoxicated, correct?
Correct.
And that put her in fear because at some point, maybe a year ago, he had said that he would burn the house down.
Correct.
And that the night of the incident that she attempted to take out a TPO against, the behavior that he was exhibiting was burning yard waste in the front yard of his own home, correct?
Yes.
And that PTO was never, that PTO was, or the TPO, I'm sorry, was dismissed by Alina, correct?
Yes.
And so what you're reading is simply just the petition for her to get that TPO, correct?
I'm reading the petition for her to get the TPO. I also want to add that as part of that TPO, the petitioner talked about physically abusing the petitioner's dog in front of the petitioner and the petitioner's daughter.
And you didn't think it would be important to speak with Alina to figure out more about what that abuse may have entailed?
I did not.
And that TPO was never granted because it was dismissed by Alina, correct?
That's correct.
And you didn't think it would be important to talk with Alina about why it was that she dismissed that TPO before having it granted?
I did not talk to Aaliyah.
And did you happen to read an interview summary of an individual, Mr. Coleman, who interviewed Alina?
Could you back up, slow down, and
Sure.
just ask me that again?
Sure. Did you happen to read an interview summary of an interview that was conducted with a Mr. Coleman and Alina?
No.
So defense did not provide you with a transcript of an interview that was done with Alina,
I don't believe so.
where Alina stated that Mr. Barron had never been physically violent to her? You weren't aware of that?
No.
I want to talk to you a little bit about your report. On page 12 of your report, do you have your report in front of you?
I do.
Okay. On page 12 of your report, you noted in there that Ms. Mericle denied that Kevin Haley was ever physically abusive to her, correct?
That's correct.
But your testimony today was that Mr. Haley was physically abusive to her.
Well, I learned new information since the writing of this report.
But Ms. Mericle told you that he was never abusive to her, correct?
That's correct.
And on page 13 of your report, you are talking about your interviews that you conducted with the defendant's sisters, correct?
Yes.
One of which being Leslie, I don't know, Flournoy. I'm probably mispronouncing that, but Leslie.
Yes.
Yes. And Leslie told you about a time where this defendant strangled her, correct?
Yes.
And that basically they were dividing up their mother's jewelry and Suzanne came after me and put her hands around my throat, correct?
Yes.
And that Leslie, the defendant's sister, said you never knew what was going to set her off, correct?
Yes.
And
I would also add that Ms. Flournoy was clear that, in her opinion, she personally was the target of the violence.
Sure, because she was the one strangled, correct?
Because she thought that of Ms. Mericle, like Ms. Mericle really only directed violence at her younger sister.
Okay. And because of that, they didn't speak for 8 years, correct?
I don't think it was because of that specific thing.
So in your report, you wrote, she stated that she and her sister did not speak for about 8 years following an incident shortly after their mother passed, and then you go into details about that incident, correct?
Yes,
So safe to say, based off your report, it's likely that they did not speak for 8 years because of the incident where the defendant strangled her, correct?
correct.
And I think we talked about this at trial, but you did not attempt to gain any sort of psychological records by the defendant at all, correct?
I attempted to, but I didn't get any.
Didn't get any.
That's correct.
So for example, any sort of counseling or psychological records back when she was dating Mr. Haley, correct?
Correct.
And same thing when she was dating Mr. Hagan, correct?
That is correct.
And we can't, you mentioned first marriage, and that Ms. Mericle told you that her first husband was controlling and emotionally abusive, I think you said?
Yes,
And he's unavailable for interview because he's deceased, correct?
that's correct.
And Ms. Mericle also has another husband that's also deceased, correct?
Yes,
And then there is a living husband, which is Kevin Haley, correct?
yes,
And Ms. Mericle told you that Mr. Haley hadn't been physically abusive to her, but then you stated you found out new information after your interview with the defendant
after trial.
after trial. Okay, so didn't even, all of a sudden now after trial, Mr. Haley was physically abusive to the defendant?
I found out that information after trial.
Okay. Did you ever attempt to reach out to Mr. Haley?
I did not.
Didn't think it would be important to hear his side of what happened between him and the defendant when they were married?
I didn't reach out to Mr. Haley.
So you're only taking the defendant and her family's word for everything that you've testified to today, correct?
That's correct.
How about Mr. Hagan? You ever attempt to reach out to him?
No,
How about anyone in Mr. Hagan's family? You ever attempt to reach out to anybody?
no,
And it seems pretty clear that the people in the defendant's family were aware of the defendant making allegations of physical abuse against Mr. Hagan, correct?
that's correct.
Because she had told all of them about Mr. Hagan being physically abusive
After the fact, yes.
after the fact. And it's your understanding that the defendant had never told anyone about any physical abuse with Mr. Barron, correct?
That's correct. Although I take that back. It wasn't, I don't think it was exactly physical abuse, but she had certainly relayed incidents where he had behaved abusively by like throwing her stuff out the window.
Okay. No physical violence, though.
That's correct.
And I want to talk about PTSD. So, well, firstly, you talked with Mr. Willis about significant contributing factor, and he asked you, that doesn't mean cause, and you said, no, that doesn't mean cause, correct?
Correct.
Did you do any legal research to come to that conclusion?
No.
Read any case law about what it means to be a significant contributing factor?
So this is a really sticky situation because the way that the law is written is very similar, if not exactly alike, how a psychologist would report. So in a psychological report, we would never use words like cause. I would use words like substantially contributed. It happens that the way that the law is written is very similar.
Sure, so psychology and law are two totally different things.
That's correct.
And so legally speaking, you haven't done any legal research as far as what it means to be a significant contributing factor, correct?
That's correct.
And at trial, and forgive me because I know you called it something and I just can't remember what you called it, but with PTSD, there's like, I think it was like an index event, or is that what it's called?
Yes,
And is it an index event? Is that correct?
it is.
Okay, where basically you look for the index event, which is the event that stands out in that individual's mind the most, that may contribute the most to their PTSD symptoms, correct?
That's correct.
And your determination was that the index event in this case was the night where Mr. Barron put the gun, where Ms. Mericle said he put the gun in her mouth, correct?
That's correct.
Which was the night of the murder.
That's correct.
And so after all your evaluation, the index event, the most traumatic event to Ms. Mericle was the night of the murder, correct?
That's correct.
The index event was not abuse that she alleged occurred by her stepfather, correct?
That's correct.
And the index event was not abuse that she alleged occurred by Mr. Hagan, correct?
That's correct.
It was what she said happened the night of the murder, which was Mr. Barron putting a gun in her mouth.
That's correct.
And at trial, we also talked about the jail counseling records. You had reviewed those as well, correct?
Yes.
And a lot of those records, there was indication of the defendant having trouble adjusting to life in jail, correct?
Yes.
And she was disclosing to the jail psychologist that a lot of her anxiety was stemming from her fears about ever being able to get out of jail, correct?
Yes.
And she was having difficulty sleeping in the jail due to fears of basically being in jail, correct?
Partially, not entirely.
Sure, yeah, not entirely, but there was a repeated pattern in those psychology records of Ms. Mericle exhibiting anxiety based off of her current living situation in jail, correct?
Yes.
I don't have any other questions, thank you.
Thank you.
Thank you for your testimony.
That's it.
Oh, we have, thank you.
I'll take those if you don't mind. Thank you. Can I see them?
State calls Investigator Matthew Mefford.
Thank you.
If you could raise your right hand, do you swear affirm the testimony you'll give the court the truth, the whole truth, and nothing but the truth, so help you God?
Thank you.
I swear.
Thank you. You can take a seat. Would you go ahead and just again state your name and where you work?
Investigator Matthew Mefford, M-A-T-T-H-E-W, M-E-F-F-E-R-D. I work with Hall County Sheriff's Office.
And were you the lead investigator on the case against Suzanne Mericle?
Yes.
As part of your investigation, did you speak to any of the defendant's exes?
Yes.
Who did you speak with?
I spoke with Mr. Kevin Haley and also a Mr. James Terry Hagan.
So I want to start with Mr. Kevin Haley first. When was your understanding of when the defendant and Mr. Haley were married?
2010-ish to 2018-ish.
2010 to 2018?
Yes.
And did Mr. Haley talk to you at all about his marriage with the defendant?
Yes.
What did he say?
Ultimately, he said there was a few times where she was aggressive, but he highlighted one incident where they went to dinner one night. Miss Mericle got mad because his name was at the top of the tax returns at the restaurant. She just kept getting madder and madder. And I believe he said that who was it, McLean and Mary Madden were with them. They get home and the kids go in the house. He stayed in the car. She came around and hit him with a closed fist.
Was that the first time that the defendant had struck Mr. Haley?
With a closed hand. But,
What about other times?
he indicated there were other times where she would slap him with an open hand.
Did he say how many times the defendant had slapped him before?
He estimated 3 or 4.
What were his feelings towards the defendant? Like, did he have any fear for her?
Yes.
What did he say about that?
He was very afraid of her. Find the notes. He said he would 100%, or she would 100% come after him when he tried to leave. And he detailed other times where he did try to leave and she did come after him.
When he would try and leave, what did he mean by, I guess, first, what did he mean by try and leave? Like, where would he go?
Just try to leave the house. I'll detail, he went through extravagant means the time he actually did leave for the divorce. Went through hiding his car before going to the airport and staying the night in New York. But he would go to friends' houses, I believe.
And would she attempt to locate him when he would leave?
Yes.
In what ways?
Come chase him down.
Chase him down?
Yes.
So, before we talk about the night where he left, I want to ask you about Mary Madden. Is Mary Madden the defendant's daughter?
Yes.
did he ever witness any abuse against Mary Madden?
He said, yes. He talked about one night she pinned her in a door and cut her arm. And then Mary Madden went and talked to their pastor, I believe, about it, and DFACS became involved at that point.
And throughout your investigation, did you locate a police report associated with that event?
I know I relocated the DFACS referral.
DFACS referral?
Yes.
And so Mr. Haley, it sounds like he was married to the defendant at that time.
Yes.
In the DFACS referral, do you remember what Mary Madden stated to DFACS reporters?
I do not remember off the top of my head. I have not reviewed the
Would it-
referral since the,
Would it help to see that report to help refresh your recollection?
yes, please.
Judge Perez, you approve? Let me know when you're ready.
Oh, wait, yes.
And did Mary Madden speak to DFACS workers?
I believe so.
And what did she say about what the defendant did to her?
She was very mean to her. She pushed her against the wall and caused a scratch on her arm, was the brief, yes.
And as a result of DFACS reporting for this incident, was Mr. Haley involved with that DFACS investigation?
Yes.
And tell me about what he said about his involvement with that DFACS investigation.
DFACS would come to the house weekly for about a month, and prior to them coming, she would coach him, tell him what to say, stuff like that.
Talking about the night where Mr. Haley left, was that the night that you were testifying about where they were at the restaurant?
Yes.
And why was it that the defendant got angry, according to Mr. Haley?
His name was at the top of the tax returns when she made more money.
And so she was just upset that his name was on the top, even though she made more money?
Yes.
And so what happens after they get in this verbal argument at the restaurant?
They leave she kept getting madder and madder, he said, and they left the restaurant. And when they got home, the kids went inside, and she came around. He remained in the car, and she hit him with a closed fist.
And what did he do after that?
He left and never saw her again.
Immediately, did he get out of the car? Did he just turn around and leave?
I believe he left. He left his stuff, or I can't recall. I can look at my notes.
And if you need a second to look through your notes.
Please.
To help refresh your recollection.
Oh, yes, okay, sorry, yes.
Did he get out of the car? Did he just back out of the driveway and
No,
leave?
he did. He got out of the car. He said this is the first time she'd done that, talking about the closed fist. He was sitting in his car, head out of the window. She was out of the car, she was out of the car. He went upstairs, tried to keep his cool, started packing his suitcase. She was screaming and crying, she's so sorry. He put everything he had in the suitcase and drove to Jacksonville Airport and flew to New York and never saw her since.
Did he explain why it was that he drove straight to the airport after that incident?
Because previous incidents, whenever he tried to leave, she would locate him, chase him down and apologize and get him to come back home.
So where did he go after driving to the airport?
He flew to New York.
And were they still married at this point of this incident?
Yes.
And then is it your understanding afterwards is when they got the divorce?
Yes.
And I think your testimony was that Mr. Haley never saw her again after that?
That is correct.
Did he explain why he never saw her?
He just never wanted to see her. He even commented that he was sweating thinking about it right then. I don't recall exactly, but we did talk about it, but
Did he have any opinions in regard to the defendant's temper?
yes. Let's see. She did say that she thrived on confrontation, whether it be with him or her employees. She had a temper, and she loses it very easily.
And then you mentioned that you spoke with James Terry Hagan as well, correct?
Yes.
And when do you know the date of when you spoke with Mr. Hagan?
March 26th of 2025.
So at this point, had any details of the murder been disclosed at this point in time when you spoke to Mr. Hagan?
No.
Did you, before speaking with Mr. Hagan, did you explain to him any of the facts of the case that you were investigating at that point?
No.
Did Mr. Hagan talk with you about his relationship with the defendant?
Yes, he just insisted his attorney be present.
And was his attorney present?
Yes.
And what did he say about the defendant?
They were off and on for about a year. They dated for 6 to 8 months, between 23 and 24. And stated that Suzanne's demeanor during arguments depended on her medication, alcohol consumption. He stated that if she took those things, you would see a different side of Suzanne, and that her drink of choice was vodka.
Did he ever mention the defendant? Was the defendant ever physically abusive to him?
He outlined two occasions.
And what was the first occasion that he outlined for you?
I believe it was the Birmingham.
And did Mr. Hagan ever talk about trying to leave the defendant?
Yes.
What would he say about that?
That was one of her triggers. That I'm out of here, you're crazy, and that would kind of set her off. She'd become combative and abusive.
And so what did he say about the Birmingham incident?
He said he was defending himself. He was trying to pack his bags and leave, and she was jumping on him. And then her injuries came of him slinging her off.
And specifically, if you could, so he's trying to pack his bags and leave.
Yes.
And what does he say about what she did?
She was like a possessed person, jumped on his back when he was packing his bags to leave from the hotel. She started wailing away because he was leaving, and he had to sling her off of him. She came at him over and over, and he had to defend himself.
And after that incident, do you know if they remained together, if they continued to date?
That was Labor Day of 23. He did talk about after that, she sold her house and bought a condo, 2 condos away from his, but I believe they were broke up when she bought that condo.
So what's your understanding of who lived in that condo complex first?
Mr. Hagan.
So Mr. Hagan lives there. Defendant, what does he say about what the defendant did?
She bought a condo, 2 condos away from his, so she keep an eye on him.
And were there any incidents that occurred after that in the condo complex?
Yes.
What did he say about any incidents in the condo complex?
In June of 24, he said he was at his condo in bed watching the news. Suzanne started texting him and came to his condo. Mr. Hagan stated she entered his condo. There was a confrontation at the door. Mr. Hagan said he removed himself from her, locked himself in his bedroom, and Suzanne started throwing things and went irate. Mr. Hagan stated that she slapped him, knocked the phone out of his hand, knocked his eyeglasses off, and became aggressive. Mr. Hagan stated that he grabbed her wrist, she fell onto the floor and started kicking him. He grabbed her ankles, and he was finally able to drag her out of the door.
And so this is is it your understanding this is the condo complex in St. Simons?
Yes.
And so Mr. Hagan stated that he had to lock himself in his bedroom door?
Yes.
Did Mr. Hagan know any of the facts of the case, the murder against Mr. Barron?
No.
To your knowledge?
To my knowledge, no.
And this is March 26th of 2025, so this is maybe a couple weeks after the murder that you're speaking with him?
Yes.
So after that incident at the condo complex, what's your understanding of when the TPO that Mr. Hagan took or got taken out against him came out? When's your understanding of when that happened? Was that before or after the condo
I
incident?
believe 2 weeks after that incident.
And did Mr. Hagan talk to you about the TPO that was taken out against him at all?
Yes.
What was said about the TPO?
His attorney was actually the one that made the comment. They advised they wanted to keep the TPO because it also would keep Ms. Mericle away from Mr. Hagan.
So was it your understanding Mr. Hagan wanted protection against the defendant?
Yes.
Did they ever, after having the TPO put in place, did they ever run into each other anywhere?
Yes.
Where was that?
An incident occurred at the Harris Teeter grocery store.
What did Mr. Hagan tell you about that incident?
Mr. Hagan was there first shopping. When Ms. Mericle arrived, she started making a scene accusing Mr. Hagan of stalking her. The attorney stated the security camera footage showed Ms. Mericle approached him and caused the scene.
So what's your understanding of who was at the Harris Teeter first?
Mr. Hagan.
And what's your understanding of who approached who in that Harris Teeter?
They alleged that according to the video security incidents, because the police were investigating, she approached him.
And were there any criminal charges or anything taken out by anybody because of that Harris Teeter incident?
None that I know of.
All right, I don't have any other questions. Thank you.
Prosecutor Mefford, I want to ask you questions about, go back to the Kevin Haley
Yes.
person, or I guess topic that you discussed, okay?
Yes.
Did you attempt to interview anyone other than Mr. Haley about their relationship?
About Mr. Haley's relationship?
About Mr. Haley's relationship and Ms. Mericle's?
No.
Did you speak to Ms. Mericle's children who were allegedly present for this prior incident?
I didn't think they would speak to me.
Okay. You didn't think it'd be important to talk to the people who were present for
I would
the,
have loved to, but being the arresting person that arrested their mom, I don't think they would have spoke to me.
that was a choice that you made, though?
Yes.
Okay. And so we're stuck with, as far as you're concerned, Mr. Haley's version.
Yes.
Did you ask Mr. Haley about his insistence that Ms. Mericle get a breast implant?
I did not know about it because she did not speak about it in my interview with her.
Did he tell you, or did you ask him anything about him trying to bring a third woman into their marital relationship?
No.
I want to ask you about Mr. Hagan, okay?
Yes.
The first thing that you said, I think, was that when you talked to Mr. Hagan, he insisted that his attorney be present.
Yes.
He didn't want to talk to you alone.
He didn't know what she was capable of, I believe. So yes, no, he wanted his attorney present.
He didn't know what she was capable of, so he needed his attorney in
That
your
was
interview?
iterated throughout, but yes.
Okay. His attorney in the interview was going to make sure that she wasn't capable of something.
Just for his safety, I guess.
Okay. So him and his lawyer came and sit down with you?
No, it was a telephone interview.
Telephone. Have you ever seen Mr. Hagan face to face?
No.
Okay. All right. This was like a conference call, maybe like on speakerphone or something?
Yes.
Okay. Okay. And you knew by the time you talked to Mr. Hagan, and maybe you didn't, so tell me if I'm right. Did you know, is a better question, did you know by the time you talked to Mr. Hagan that he had been previously arrested for assaulting Ms. Mericle?
Yes.
You already knew that?
Yes.
You knew then that police had showed up at a scene, assessed the situation, right? Correct? Police had come to a scene in Birmingham.
I don't want to misspeak, so let me think for a second, because I remember getting the report. And in the interview, she did talk about Mr. Hagan, and I don't want to get my timeline mixed up for you, but I don't remember if it was after speaking to him that I did get a copy of the report from Birmingham, detailed or not, so I don't want to answer that
So
directly.
in other words, when you're talking to Mr. Hagan, you may not have even had the report at that time.
No, I don't
Okay.
remember the day I got that.
Interesting. Okay, so later you get the report after you've talked to Mr. Hagan, maybe.
I got the report, yes.
In any event, you know that police did show up to the Birmingham scene.
Yes.
You know that two separate callers called concerned.
Yes.
not just one, but a second person also called, right?
Yes, I believe so.
And when the police show up, they find Miss Mericle with injuries.
Yes,
And the police make the determination that Mr. Hagan has assaulted Miss Mericle.
yes, that he was arrested that night, I believe.
Right, and charged with an offense against Miss Mericle.
I believe so.
But according to Mr. Hagan, he was just defending himself,
Yes,
okay? And you were willing to go with what his version was.
I find from investigating these things, they're somewhere in the middle, but yes.
Okay, fair enough. Okay. Thank you.
No further questions, Your Honor.
Thank you for your testimony.
Judge, state calls Beth Barron. If you could, ma'am, raise your right hand. Do you swear affirm the testimony you'll give the court the truth, the whole truth, and nothing but the truth so help you God?
I do.
Thank you. You can have a seat. Would you state your name again for the record?
Beth Barron.
And Ms. Barron, you were married to David Barron, correct?
I was.
How long, can you just give us the dates of when you were married?
We were married in 1979, so we were married 22 years.
So 1979 plus 22 years?
Right.
Okay. And throughout that 22 years, was Mr. Barron ever physically violent towards
No.
you?
No, never.
Did you ever fear that he might become physically violent towards you?
Never. No.
What was his demeanor like throughout your marriage?
David was calm, collected, cool, loving. He was very respectful of me. He loved our family. He was a great family man, a good father, a good grandfather, just a wonderful guy. Yeah.
When you would get into arguments, as every married couple does, like what would those arguments look like?
David usually retreated from an argument. He did not like confrontation, and he would just try to leave the situation.
After your marriage ended, did you remain close with David?
I did.
How often would you speak with him, would you say, up until the day of his
Every
murder?
few weeks, we talked about children and grandchildren and just events in our lives.
How was the co-parenting relationship between you and David?
It was good. It was good. We worked it out.
And is there anything else that you'd like for the court to know about how this has impacted you?
Yeah, I do have a statement. David was the foundation of our family, the patriarch. He was the leader of our tribe. Excuse me. He was respected, and we loved him dearly. He was a gentleman, a kind soul, a truly good human. He was generous and fun-loving. He was a talented athlete and a success in business and in his community. He was large and larger than life. He was the oldest brother, father of Evan and Colt, and grandfather to Emmy, Brooke, Maddie, Charlie, and Tyler. He was an uncle, a cousin, a friend, and a mentor. And on March 8th, he was taken away from us, killed in the worst way, shot behind a locked door by a jealous, selfish, crazed person. Suzanne not only took his life, but also tried to defile his character during the trial in the most vulgar way possible. The impact of her actions have left our family with a void that cannot be filled. The pain I have seen in Evan and Colt this year has been horrendous. Our hearts are completely broken, and I have not seen 1 ounce of remorse in Suzanne. No guilt, no sorrow, no shame in what she has done to our family. No tears, just a blank stare. And I would like to ask the court for the maximum punishment for Suzanne today, life with no parole.
Thank you, ma'am. No other questions?
Okay.
I have just one follow-up, and it's obvious that you have a very deep affection for your ex-husband. And I know that you feel very strongly about how he was supportive of you and of the family even after your divorce. And just to, I guess, just to complete the picture, if you will, it would be fair to say, and I think you've said before, that the biggest issue that you had really in your relationship with David was with alcohol. Is that fair?
No, I've never said that.
You didn't have an issue with him with drinking in the
No.
end of your marriage?
No, not at all. That was not our lifestyle. He went to church. He taught Sunday school. That was not our life, and that was not our lifestyle at that point. So I don't know beyond that, but alcohol was not an issue with us.
Okay, thank you.
And state calls Laura.
Your excuse, thank you.
State calls Laura Phillips. And if you could, ma'am, raise your right hand. Do you swear or affirm the testimony you'll give the court is the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. You can have a seat. And can you say your name for the record?
Laura Phillips.
And were you married to David Barron?
Yes.
What were the years of your marriage to him?
2004 into 2014.
Okay. So 10 years you were married?
But we've been seeing together almost 3 years,
3 years?
living together.
Okay.
Yes.
And throughout that 10 years of marriage, was Mr. Barron ever physically violent to you?
Never.
Did you ever fear that he may become physically violent?
No.
Tell me about what his demeanor was like throughout your marriage.
He was a caring, kind, gentle soul.
And when you would get into arguments, what would those arguments look like with David?
We didn't have arguments,
What about disagreements? Did you ever get into disagreements?
of course.
And what would those disagreements look like?
I wouldn't even describe it as disagreements. We always worked it out together.
Was there ever any yelling between the two of you in your marriage?
Never.
And at some point throughout your marriage, did David begin to drink alcohol more than when you first met him?
We drank socially.
What was his behavior like when he would drink alcohol?
He was a happy person.
So like, some people get angry when they drink, some people get happy, giggly when they drink. Like, how would you describe his behavior when he would get intoxicated?
Happy and giggly.
What about when he would like drink too much? Like, what would happen then?
He would just take a nap.
take a nap,
Right,
just get sleepy.
right.
Would he ever get physically violent or aggressive when he would drink alcohol?
Oh, never.
Is there anything else that you'd like for the court to know about how this has impacted you?
Yes. I never, ever imagined that this would ever happen to David. He was very kind and caring to me and my family, and certainly his side of the family. We coexisted very well, loving, caring, respectful. And it deeply saddens me that this is how it ended his life, through a volatile, psychotic woman. And it's extremely tragic, and I'm deeply hurt myself personally. He was a good friend even after our divorce. We stayed in contact. And I feel for the family, and I pray for the family to move forward in memory of their father, beloved grandfather. And I miss him as a friend too.
And did you remain friends with him up until the day that he was killed?
Yes.
And up until the day that he was killed, did his behavior ever change from what you knew him as when you were married?
No.
Thank you. I don't have any other questions.
No questions, thank you.
Thank you for your testimony.
Judge, the state has no more rebuttal evidence. We just have victim impact statements. So as far as procedurally speaking, would Your Honor like for us to move into the rest of the victim impact statements?
Y'all tell me. I was planning on giving you a ruling pursuant to 17-10-22 and then go from there.
And so Your Honor would like to do a ruling on the statute and then move into victim impact statements?
That's where I thought we were going.
That's fine. I think that's appropriate, Judge. I guess we'd have to move an argument then first as to the statute before getting a ruling. And I go first. It's their burden. So is that okay with Your Honor?
Yes.
Okay. Judge, I just want to give Your Honor one case. I made a copy, Your Honor. May I approach?
Thank you.
As well as defense. It's a New York case. Obviously, Judge, the statute is new for Georgia. It was just enacted less than a year ago. So as far as case law for Georgia, there really isn't any. But I wanted to give this case up to Your Honor. The reason being, I know that we received a brief from defense as far as 17-10-22. And in that brief, there was a citation to a 2021 case that essentially talks about causation. And as Your Honor knows, basically, the burden that needs to be met is first and foremost that the defendant was subjected to acts of family violence by anybody in her past. Second, they would have to prove that it was such acts were a significant contributing factor to the offense. State would obviously be objecting to any indication that she was subjected to family violence by anybody. I think that as far as Mr. Barron is concerned, the jury verdict speaks for itself as far as violence, self-defense. If the jury thought that Mr. Barron had attacked the defendant the night of the murder and she was acting in self-defense, we wouldn't be here today. As far as Mr. Haley and Mr. Hagan, all of the evidence as far as abuse by both of them, I think the mic keeps going on and off, Judge, I apologize.
If you don't mind, let's switch that one out. Let's make sure it's on. If you would turn that one off. Thank you.
This one seems to be working. As far as Mr. Haley and Mr. Hagan are concerned, you have two different individuals who were both, one married to the defendant, one that dated her, and for over a year. And both of them experienced very similar lifestyles with her, which is her volatile, aggressive behavior. She was physically abusive to both of them. Both of them, interestingly enough, talked about the difficulty with them trying to leave in the middle of an argument. Mr. Haley, there was testimony from Investigator Mefford that Mr. Haley would try and leave when they would get into arguments, and she'd slap him and she would chase him down, so much so that the night that he finally did leave her, he took the extraordinary measures of driving to the airport and flying to New York, never to see her again. That was the only way that Mr. Haley knew how to get away from this defendant and her aggressive, violent behavior. You also have Mr. Hagan talking about how he would try and get away from her, and that the night of the Birmingham incident, he was packing bags trying to leave, and she attacked him. Similar to many of the facts and circumstances we have in this case with Mr. Barron, where Mr. Barron continuously is having to flee to hotels, having to flee up into the guest bedroom to lock himself behind the guest bedroom door. Very similarly to Mr. Hagan's experience, where he's at his condo and had to lock himself behind his bedroom door to get away from the defendant. And this is weeks after the murder, Judge. This isn't after the trial he made that statement. Mr. Hagan had no idea the facts and circumstances surrounding the case with Ms. Barron, with Ms. Mericle, and he makes the comment about having to hide behind his locked bedroom door. There was evidence of this defendant following Mr. Hagan. She bought the condo 2 doors down from him after he lived there. And the reason I think that is important, Judge, is there was a lot of testimony at trial in relation to Mr. Barron, where the defendant was basically trying to, in the text messages, make Mr. Barron feel bad about, I have to go back to my condo with my crazy ex who lives there. You don't even care about, the fact that I have to go back there where he lives. Well, she's followed him there. The reason why she has a condo 2 doors down from her ex, who allegedly was abusing her, is because she purchased that condo after he already lived there. So as far as any credibility from any of the allegations from this defendant, I don't think that this defendant has an ounce of credibility left to her name after this trial. I don't believe that there is sufficient evidence by a preponderance that either of those 2 exes were abusive to her. The only evidence we have of her stepdad abusing her is, again, her statements made to Dr. Elcon, who, again, as far as credibility being shot, I think that was pretty much established at the time of trial as well, Judge, as far as Dr. Elcon's credibility. You have a psychologist who's going to get up on the stand and testify that she believes all of these things are a significant contributing factor to the defendant's behavior without even getting any of her counseling records, psychology records when she was dating them. She doesn't make any attempt to speak to any of these people. She doesn't make any attempt to speak to the woman who tried to take a TPO out against Mr. Barron that ultimately was dismissed. Makes no effort to corroborate any of the statements made by this defendant to her. She just takes everything that this defendant is saying to her, as the absolute truth, and that's that. Furthermore, Judge, as far as the significant contributing factor element of this statute, let's say, setting aside the domestic abuse, let's say Your Honor believes that Mr. Hagan abused her, and we want to believe that anything that this defendant said was true. Well, then we need to establish whether or not that abuse was a significant contributing factor to the offense. And the reason why I gave you, Your Honor, this case is because defense is citing to a 2021 New York case where the court essentially said, okay, well, significant contributing factor doesn't necessarily mean causation. And that's kind of the main issue, is did this abuse cause this behavior? It was what New York was trying to figure out. And defense is going to say no, that this 2021 case says no. The reason I wanted to give Your Honor this case is Mr. Bullard made this exact argument in DeKalb County with that exact 2021 case, and it was not successful because of this 2023 case. And the reason being is this 2023.
Counsel stating about cases that supposedly.
I can't hear you.
I have to object to counsel falsely stating about cases that co-counsels have argued that we haven't.
I don't know whether it's false or not false. I would assume that all lawyers are operating under their sworn duty as officers of the court. So I'll take the state at their word on that. That being said, I don't know how much it does or doesn't matter because it's a separate case. However, I will allow her to make her argument in her concluding remarks.
Judge, and what I did was I went ahead and highlighted some of the more pertinent aspects of this case, specifically on page 14 and 15 of this New York case. It's People v. BN, for the record, 79 MISC 3D 740. It's a 2023 case. And what the court in New York is, and the reason, again, we're citing to New York is because there is no Georgia case law.
I understand.
But the Georgia statute mirrors the New York statute as far as the language with being a significant contributing factor. And what this New York case from 2023 states is that basically causation is embedded within the definition of significant contributing factor. And what the courts in New York did was they even whipped out Webster's dictionary as a definition for the ordinary meaning of statutory words incorporates causation. It says, according to Webster's dictionary, significant means having or likely to have influence or effect, important of a noticeably or measurably large amount, probably caused by something other than mere chance. Contribute means to play a significant part in the making something happen. Contributing factor means something that helps cause a result. Thus, the plain language used in the statute did not dispose of causation, it incorporated it. The legislative history requires causation. And the court further states, the legislative history contemplates causation. It speaks about victims committing crimes because they were reacting to abuse, protecting or defending themselves or their children, acting as a result of abuse or being coerced into committing crimes. There is no way to read this language and rationally conclude that causation has been eliminated as the defendant urges. If substantial contributing factor does not require any degree of causation as the defendant urges, then any offender who has ever endured domestic abuse is eligible for relief, even if there is no articulable link between the abuse and the criminal conduct. This would cast a broad net that most offenders in the state would be eligible, not just a small fraction contemplated by the legislature. The reason why that's important, Judge, is because significant contributing factors is very high standard, and it's that way for a reason. Even if Your Honor finds that this defendant was abused by an ex in the past, Your Honor would then have to find that that abuse by, for example, Terry Hagan, caused her reaction to Mr. Barron, caused her response to Mr. Barron the night of the murder. In order to find that, Judge, Your Honor has to find that Mr. Barron did anything in the first place. Because if Mr. Barron, if everything that this defendant said is a lie, which the state obviously argues it was, and Mr. Barron didn't put the gun in her mouth, didn't strangle her, didn't do all the things that she said that he did, then there's no trigger for her to have any reason to act the way that she did. The behavior has to have been caused because of the abuse. And the jury's verdict speaks volumes as to whether or not this defendant was being honest about Mr. Barron the night of the murder. And that verdict, the state is arguing, shows that Mr. Barron, I believe, did nothing the night of the murder. I believe the evidence showed that Mr. Barron didn't even have the gun the night of the murder and that it was planted by this defendant. And because of all of that, Judge, there's no significant contributing factor to her behavior the night of that murder, because what the evidence showed was that Mr. Barron was hiding and was defending himself up in the bedroom behind the locked door when this defendant was angry and walked upstairs and shot and killed him through the locked door. There is no evidence that any alleged abuse that she experienced in her past could have in any way been a significant contributing factor to what this defendant did the night of the murder because there's been nothing to trigger that behavior. And something that I find interesting about Dr. Elkon's testimony is that she diagnoses the defendant with PTSD with the index event being the night of the murder. But then defense wants to argue that this defendant suffered from PTSD from all of her past, and because of her past and the PTSD, that's why she reacted the way she did the night of the murder. But their own expert is refuting that exact argument, that this defendant, based off of her testimony, to me sounds like she's suffering from PTSD because she murdered Mr. Barron. And she is now exhibiting symptoms of PTSD in the jail because she's murdered someone and then wiped up her boyfriend's blood, staged a crime scene, and now is in jail for murder. That's why this defendant has PTSD symptoms in the jail. And the jail records, both at trial and today, are a huge indication of that. She's consistently disclosing to the jail nurse about her anxiety she's having being in jail, never getting out, the nightmares about the night of the murder. All of those things point to, if we believe that this defendant is having any PTSD symptoms when she met with Dr. Elkon, it's because she murdered Mr. Barron. And based off of defense's own expert, that appears to be the case. So based off of all that, Judge, the state would ask that Your Honor not sentence the defendant under 1710-22 and proceed with normal sentencing under felony murder.
Thank you.
Can you hear me okay, Judge?
Thank you.
The defense memo that we previously provided to the court sets out the true framework for 1710-22, Judge. You may be one of the first courts to be imposing sentence under that statute. I don't know of any other courts who've done it yet. As the court knows, it was passed into law and became effective in July of 2025. And as our memo explains, a life punishable offense permits the court to change the range to 10 to 30. And it's important to note that actually that 10 is probatable. You have the kind of discretion that you would on any normal felony. It doesn't have a 10 floor, if it please court. What does it require for the court to make the finding? It requires evidence that the defendant was subjected to qualifying abuse and that the abuse was a significant contributing factor to the offense for which she stands convicted. And what we have here, as the court knows, is a conviction for a reckless act. Not an intentional act, not a malice murder, not an aggravated assault, not even a reasonable apprehension aggravated assault. The state submits to you that the jury, I think what Ms. Bennett said was the verdict speaks for itself. It rejected acts of violence by David Barron. I don't believe this verdict does that whatsoever. What the jury found is, in essence, that she committed a reckless act by shooting a door. What is the difference between shooting a door and, what is the difference between an involuntary manslaughter, reckless conduct, and what she stands convicted of? Only one thing. That's the interposition of a door. That's it. I don't believe the verdict speaks anything about her intent, Mr. Barron's acts. None of those things are contained within the verdict. What the jury found is, in essence, was what she told them in the interview right off the bat, which was tried to shoot the door to open the lock. And, you know, whenever you hear that, you go, that sounds awfully reckless, right? Just like that's what the investigator said to her. And that's ultimately what the jury decided. But when you're determining whether you have a significant contributing factor, Judge, I disagree slightly with the way that Ms. Bennett characterized those cases. It's clear that it's not the same as cause. That's clear. You don't have to prove the but-for cause or the cause in fact. It has to be a significant contributing factor, period. It doesn't have to justify the act. It doesn't have to amount to a self-defense or justification or defense of others. None of those things have to be met. And it doesn't even have to be the exclusive or even the overriding factor. What you learn from Dr. Elkon's testimony is they borrowed heavily, and in fact, I would suggest just took directly from psychological literature. This is designed and taken directly from DSM and psychological literature. That's why they use this term, significant contributing factor. That's where it came from. How do you show it? Well, you show it by presenting psychological testimony from an expert, which we've done. Really what the court's looking at here is whether all of this history, not just what happened on March 7th and March 8th, all of this history is sufficiently significant to have likely helped bring about that behavior. Is it sufficiently significant to likely bring about a reckless act in exactly the way that you heard it took place here? Shooting at a door to try to shoot the lock off, to get inside, to reclaim a stolen telephone, and to get out of the house. And I think the jury probably struggled with the idea that self-defense could be committed when you don't intend to actually kill someone. And that's a strange thing. I don't know that I've had a case like this before, but I don't believe in any way their verdict rejects the things that are undoubtedly true and are proven by the evidence that you heard, most significantly the photographs of Ms. Mericle's injuries from March 7th and March the 8th, which the state admitted in their closing they didn't know where those came from. Maybe they came from her hitting against the wall, but there are some in many places where that wouldn't be consistent. Ms. Mericle said, and it's the only evidence, I got that from him grabbing me. How do we get past the photographs if there was no violence? I would ask the state that. And they have no response. They had none for the jury. They don't have one for the court. There was plenty of evidence that there was violence on this date. And again, you're not confined in looking at the significant contributing factor to just what you heard about March 7th and March the 8th. You did hear evidence that her victimization began in early childhood. She was raised in a home marked by alcoholism, constant conflict. Her parents are fighting. Her mother remarries a stepfather, and that person is kicking her brother in front of her, beating him badly, and then kicking all the other kids while her mother's at work. The children are left to raise one another, and Suzanne assumed a caretaking responsibility for even younger siblings at an early age. That's qualifying under the statute. Abuse by a step-parent or a parent is qualifying under the statute. So that's our first instance. It begins very, very young. The pattern continued into her adult life, and Terry Hagan is the crux of this. You know that in September of 2023, while they're in Birmingham, 2 persons called the police, not 1 but 2. He beat her badly enough. The police showed up, made an arrest, made an assessment, found injuries on her, and charged him. We know that she continued to be in a relationship with him through 2024. And we know that in August 26th of 2024, she sought a restraining order against Mr. Hagan. And you have that restraining order in front of you, including voluminous photographs of injuries to which the state has 0 response. Nothing. Those photographs show the truth of that relationship. You also have, as further corroboration, an interview with Suzanne's close friend who actually witnessed injuries, black and blue is how it was characterized, of Ms. Mericle at the results and at the hands of Mr. Hagan. That's what you have. And again, that I would submit is unrebutted. And the evidence is that thick. And we know that the statute does ask the court to consider restraining orders that have been submitted, sought, and granted, or even sought, and you have those. So that's also part of your determination. We know that, as Dr. Elkon testified, Suzanne was a woman with a long and tumultuous pattern in her relationships, that's for sure. She had limited self-worth. She had an intense need to be loved, a tendency to excuse past abuse and to blame herself rather than the partners who were visiting the violence on her. She was apt to return to those relationships and then to conceal the abuse from those who were closest to her. The only person who really knew of this abuse was Ms. Sellers, who witnessed it. And you'll see in the interview, Judge, I didn't have Dr. Elkon read this out, but it's in that interview. Ms. Sellers saw the injuries, asked Ms. Mericle about them. Ms. Mericle related that she had merely fallen somewhere, and then Ms. Sellers pressed and found out the truth was that she'd had this violence put upon her by Mr. Hagan. She also suffered a concussion from that attack. It's memorialized in your TPO and also in the Sellers interview. This was a significant abuse incident for her. So we know, in addition to all of this prior acts of violence, we know that these earlier abuses are part of the cumulative victimization history that makes her more vulnerable to abusive men and, again, more likely to normalize and hide that violence. And importantly, more likely to react in panic and reckless fear when Mr. Barron threatened her with the gun and took her cell phone and went up the stairs with that. You'll recall, Judge, from the trial, which obviously you're bringing in all of that knowledge that you have with you, the fact that that phone was taken from her was also unrebutted by our expert witness and virtually conceded by the state in closing argument. That's something the court needs to consider when determining what actually happened here. To have a piece of property stolen from your person, especially in combination with a threat, is it reasonable to go and shoot the door off as opposed to trying to unlock it, as Ms. Bennett demonstrated in her cross-examination of the defendant and also in her closing? The jury decided that it was not. They decided that it was a reckless act as opposed to a justified one. And that's what you're asked to impose sentence on here today. But we know the March 8th incident, on top of the history, was the trigger. We know that putting the gun to Miss Mericle's lips, telling her not to close her eyes that night, which she told over and over and over again to the first responders and through the interrogation with Investigator Mefford. You saw her hyperventilating, screaming, begging for help, repeated calls to 911. We know that she has post-traumatic stress disorder because she's been tested by a professional, and that evidence is unrebutted. It still remains unrebutted here today. The post-traumatic stress disorder was caused by this triggering event, but it landed on a past that was full of trauma and exacerbated the response, Judge. You have, I would submit, a coherent, cumulative explanation for why she acted in a fear-driven way, in a reckless way. And as Dr. Elkon told you, that is what PTSD causes. It's in the DSM-5. It literally causes a person, and prior abuse causes a person to behave in a reckless manner, which is exactly what the jury found that she had done. This was a significant contributing factor, respectfully. And again, That is the qualification. You don't have to find that it excused the offense, and that's not the question before the court. You don't have to find that it was the cause or the significant cause or the but-for cause or any of that. You just merely need to find that the testimony that was offered is correct. That's the essence. And I would submit that the record here supports that from multiple directions. And we would ask that the court make that finding with respect to Ms. Mericle. Thank you.
I appreciate both sides' professionalism and advocacy. Give me a few moments. Thank you. All right, the court will issue a verbal order, and then I believe, since it will be potentially an appellate issue, I will craft a written order mirroring the court's finding. I'm going to cut through the drama. I'm going to give you the answer, and I'm going to give you the why. I'm declining to sentence under 17-10-22. So defense's request is denied. Clearly, this case is an unnecessary and completely preventable tragedy. There are no winners here. The court clearly has sympathy for all victims of domestic and dating violence. To state clearly, these alleged past acts were not a significant contributing factor for the offense for which Suzanne Mericle has been convicted regarding Mr. Barron. To state legally, Pursuant to these alleged past acts, the court cannot find by a preponderance of the evidence standard that these were a significant contributing factor for the crimes which the defendant was convicted. Findings of fact. Much of this relates to past incidents that, quite honestly, no one really knows what happened. I do find sympathy for the stepfather issue. I have no real basis for disputing that, as was indicated by Dr. Elcon. Certainly have sympathy for the past volatile relationships, as indicated by Dr. Elcon as well. However, the court does find troubling the assertions regarding purchasing a condo after the fact, as the state's pointed out. The Harris Teeter incident, very troubling, as the state pointed out. I do find that the former spouses / partners of Mr. Barron, I do find them credible and compelling as it relates to this case and their experience with Mr. Barron. I do find also compelling, for purposes of the law as well as this court's ruling, and again, I'm very well aware that this is the state of Georgia, but many times laws are passed because essentially, and I don't know, but many times the Georgia legislature will go, hey, that's a pretty good law, maybe we should copy it here. And I would imagine that the legislative intent, even though I'm not really getting into that, is trial court judges have a very difficult job many times, or I guarantee you that sentencing is the most difficult part of any trial court judge's job. Guarantee you. It is difficult. I've spoken with many veteran trial judges, and I think there is an agreement that the most difficult part is when you are required to sentence someone to a sentence that is legally required, but the judge may not personally agree with it. So I would anticipate that this law was done as a release valve. So if someone who was convicted of a violent act, but who happened to also be a victim of domestic violence, that the legislature is signaling to the judge under this statutory framework to say, Judge, please take these into consideration because we want you, the trial judge, to deviate from the normal sentencing. That's what I think is going on here. I also think that the state, when they read from the New York opinion, and obviously their Supreme Court's the trial court and their appeals court's our Supreme Court, but essentially it's a trial court judge. I don't know the appellate history of this either way. This case, people of the state of New York v. BN, I do find it compelling and instructive as it relates to the definition of substantial contributing factor. Thus, the entire legislative history contemplates causation. It speaks of victims committing crimes because they were, quote, reacting to abuse, quote, protecting, quote, or defending themselves or their children, acting as a, quote, result of abuse or being coerced into committing crimes. There is no way to read this language and rationally conclude that causation has been eliminated as the defendant urges. If substantial contributing factor does not require any degree of causation as the defendant urges, then any offender who has ever endured domestic abuse is eligible for the treatment. Relief, even if there is no articulable link between the abuse and the criminal conduct. This would cast such a broad net that most offenders in the state would be eligible, not just the small fraction contemplated by the legislature. Continuing on, applying the plain dictionary meaning of the amended statutory words, The new standard is clear. Abuse must be, quote, likely to have or had an influence or effect, close quote, on causing the defendant's criminal behavior. The abuse must not have been of a noticeably measurably large amount, and it must have, quote, played a significant part in making the defendant's criminal behavior happen, close quote. Many other quotes that the state pointed out, but I do feel that those are compelling. I do believe that the legislature wants the court to essentially ask, not only is there a potential for a lifelong pattern of abuse, but the significant contributing factor, meaning what's that have to do with this case? What's it have to do with Mr. Barron? As you all sat through 2 weeks of this case, as well as many of y'all and the lawyers certainly sat through days of preliminary matters, the court does find the facts of this case to also support the decline of the request from the defendant regarding this sentence. Clearly, Mr. Barron was upstairs, away from the defendant. The defendant went upstairs. There was a locked door. The defendant had a firearm. There was a cover-up of her activities. These are not compelling for the defendant. I also, as was brought up in this case, I do not find credible defendant's testimony regarding her version of events at trial. I do believe that the state is on the right path as it relates to the PTSD being related to her killing Mr. Barron and the subsequent incarceration. Clearly, I'm not a medical professional, but that is a factor that appears to be more accurate than the others. To be clear, I'm declining to sentence under 17-1022. We'll proceed with normal sentencing. State, aggravation.
Judge, is it possible to take maybe just a brief comfort break, 5-minute comfort break?
There are a large amount of people here. I'll leave it to the Sheriff's Department to keep order. I will be back in 15 minutes.
Of course, in my mind, I'm thinking, Mel, and I like it, oh, yeah. No, like, no. So it's just kind of, right. Yeah. I think I have
Sorry, a little gray, we can go on that one. See it? Keep going that way. And then are you fine? Good. There's the line for you, please. Thank you so much. Thank
Oh, I was just gonna use my thing, do you care? Huh? Yeah, I just wanted to put it there. Sorry. Hey, and then I'm sorry.
Main City, come to order.
Thank you. You're good. You're good. You're good. You're good. You're good. Thank you. All right. Thank you all. Court will come to order. State, I'll start with you in a moment. For clarification, pursuant to Georgia law 1710 6.1, that the statement of life in prison is 30 years. Is that the state's understanding?
Yes, Judge, with life with prison, the defendant would not be parole eligible for 30 years.
And that's pursuant to Georgia law.
Correct, Your Honor.
Now, not getting into what policies and procedures are, but my understanding that typically equates to 32 to 35 years, give or take.
Up to the parole board at that point, Judge, but
Thank you. All right, proceed.
thank you, Judge. State would first call Tom Myers. And Judge, I'm just going to have all of them come stand at this podium if that's okay with Your Honor.
It's fine with me.
You can just come stand right here.
Okay.
I assume that's green. Welcome, thank you. For the record, please state your name.
Thomas Myers.
Thank you.
I'm the president of PM Technologies, and just like to say a few words about Dave. So I've known David for about 30 years. When I started an engineering firm back in 2001, David was one of the first people that I asked to join the organization. We had worked together in the past, and I knew that Dave had the knowledge and experience to help make the company a success. Dave was a hard-working guy and never shied away from what needed to be done. He was a vital part of the business success and became vice president of a firm that grew to engineering firm that grew to almost 80 employees. Dave built great relationships with our clients who trusted his knowledge and in judgment. But better, Dave developed great relationships with our employees. He was loved and admired by everyone at PMT. Over the years, we had many young employees, college grads, new people starting out in the business. Dave would make a point to take them under his wing, mentor them, teach them, check up on them. There were several of them, in fact, quite a few, who told me that Dave was like a father. Dave generally cared about our employees inside and outside of the office. He was a family man, and that family mentality was instrumental in building a family culture at our business that still exists today. He was, in fact, one of the finest people that I've ever known. I've known the Barron family almost as long. They're a very close family. His sons, Evan and Colt, I know personally. They're both college graduates with very good jobs, excellent families. His siblings, Greg and Cindy, I know Cindy, I know Greg. Greg worked for us at one point. The entire Barron extended family are some of the best people that you'll ever meet. The PM Technologies community will never be the same without Dave Barron. We miss him every day. His tragic, senseless death has had an enormous impact on our company. His outgoing personality, humor, and generosity are not replaceable. He is now lost forever to all of his friends and colleagues. But our loss can never compare to the damage this senseless act of violence has brought onto the Barron family. He, in fact, has 5 very young grandchildren who will never know what Dave Barron was like. None of the many people who love Dave will ever have the enjoyment of his company again. All we have is the memory of who Dave was and the good times that we shared together. I ask this court to impose a sentence that will ensure that Suzanne Mericle never has the opportunity to inflict the kind of pain and suffering that she's perpetrated on the Barron family to any other family, ever. Thank you.
Thank you for your impactful words. Thank you.
And Judge, next I'm going to read a statement from Jessa Barron. Reads, Last March, my Uncle David was taken from us in an act of violence that shattered our family forever. There is no making sense of this, and there will always be grief in knowing that such a kind, gentle, and loving man is no longer here. My dad lost a brother, my aunt lost a brother, and my cousins will never again get to hear their father's voice or have their kids grow up with their grandfather. He was always the host of most family gatherings and always made sure people were fed. No one ever went hungry when he was around. He went out of his way to include any and everyone, whether they were immediate relatives, brand new to our family, or friends who've become family over the years. Growing up, we spent a lot of time at Lake Hartwell and Lake Jackson with him, my dad, my Aunt Cindy, and Uncle Tommy, my brother, and my cousins Evan and Colt, and Uncle's sons. Weekends and holidays that weren't spent at the lake or having cousin sleepovers, we spent yelling "Go Dogs" or "Go Vols" as my dad played for Georgia and my uncle played for Tennessee. That was our only family conflict, which SEC team we were pulling. A family united but divided on football Saturdays. His oldest son, my cousin Evan, and I both lived in LA for some years, where my uncle also worked on a long-term project for Delta. During his LA visits, we spent many weekends exploring the city, attending his company holiday parties, and going to bougie brunches, although that was more of a me and Evan thing than an Uncle David thing. He loved his iced McDonald's coffee, so having to wait for French press coffee at these brunches was not a concept he was familiar with. He did not understand why anyone would wait that long for coffee. He was a simple man who loved his Tennessee Volunteers and his Dallas Cowboys, but loved his friends, family, and loved ones more than anything, yes, even football. While I am grateful that he was able to meet my daughter and my brother's kids as well as Evan's first 3 kids, it hurts my heart that he never got a chance to meet Colt's first child and Evan's first son. His life was cut way too short from a tragedy that no family should ever have to experience. I can still hear his sweet Southern voice saying, "Well, hey girl, it's so good to see you," at every family gathering. He lived by opening his home, feeding people, loving his family, and making every person feel that like they belonged. And while we carry the heartbreak of losing him for the rest of our lives, we will also carry the example he gave us on how to treat people, with warmth, generosity, and kindness. Because the violence that took his life is not the measure of his story, the love he gave us is.
Thank you for reading those compelling words.
Denise? Judge, next is Denise Bender.
Thank you. Welcome. Thank you. Please state your name for the record.
Denise Bender.
Thank you.
I am David's first cousin, and I'm reading a letter today from his sister that is not able to attend due to health reasons, and that's why she has not been here for the trial. Ms. Mericle, I will never be able to receive a phone call from my big brother and I'm having a hard time not hearing from him since March the 8th, 2025. Because of your actions, I'm not able to hear, "Hey, baby sis, how are you and Tommy?" Because of your actions, I'm not able to hear "Happy birthday," "Merry Christmas," and all the other holiday greetings. Because of your actions, I'm missing hearing his laugh, his announcements at family gatherings, him stepping up to bat on the family's matriarchal responsibilities when our mother passed. When I was born, I had 2 older brothers, Greg and David. One was an investigator, Greg, interrogating all the boys that came around trying to be suitors. David was the problem solver and fixed things. For example, when our parents were not at home, say out for the evening, and the boys would turn the living room into a football field or a basketball court, of course things would inadvertently get broken. So a little while before Mom and Dad came home, David would stop and get out the Elmer's glue and begin mending the broken lamps and things that got broken, hoping no one would notice that things had gotten broke. One evening, the parents had gone out and the boys were babysitting me. I got involved with the rough play and they knocked the scab off my arm from the TB test. Well, David's bright idea was to get the glue out and reattach the scab in hopes of no one being able to tell any difference. He is in peace now, laying beside my mother in the North Georgia Cemetery. It makes me feel so terrible that because you took his life, you left Colt and Evan fatherless. You do not know me. We have never met, and I'm glad that I never had a personal relationship with you. Natural death is one thing to try and get over, but taking my brother's life over a jealous rage is inexcusable. So, Your Honor, I'm asking you to consider the maximum sentence you can get on what she has been convicted of, murdering my brother. That way, she can spend the rest of her life thinking about what she has taken away from this family, from his loving sister, Cindy Barron Foster.
Thank you for those powerful words. Thank you.
Deb? And Judge, this is going to be Deb Barron.
Welcome.
Thank you.
Thank you. If you would state your name for the record, please.
My name is Debbie Barron, and I am David's sister-in-law. I'm married to his younger brother, Greg, and I'm Aunt Deb to Evan, Brittany, Colt, and Allie. Suzanne, I've only met you once, but very quickly realized that you needed to be the center of attention. I've known David for over 30 years. He didn't need the spotlight. His gentle spirit was always to make sure to support and encourage everyone, make sure everyone was happy and enjoying themselves and comfortable in any given situation. When my husband Greg was diagnosed with Parkinson's, a very dear friend suggested that I gather my tribe. David was part of my tribe. He was also part of the community that was to help take care of his younger sister, Cindy Foster, who was diagnosed with MS many years ago. He was always there when you needed him. He was just that person. David was all about family. Because of your choices and actions, Suzanne, so many of life's opportunities have been taken away from David, his family, and friends. David will never be able to meet his new grandsons, who were born in December of 2025, and most recently in March of 2026, while this trial was taking place. You are the woman who has been found guilty of his murder. Because of that, David will never meet them. David won't be able to see his 3 granddaughters grow and become young women. He won't be able to see his great-nephews and great-niece grow up to be adults. None of these babies will ever be able to truly get to know the gentle giant that David was. They will not benefit from his compassionate, loving spirit. They will not know his generosity, his devotion to family, and his wonderful kindness. He was not the monster you portrayed him to be. He was a kind, giving man, always willing to help, and always focused on making sure others were happy and well taken care of in any situation. After listening to all the accusations that you made during this trial and knowing the man that David was, I can only conclude that you transferred your narcissistic, selfish, insecure, jealous, manipulative, and deceitful actions and accused David of them as an excuse for your horrible crime. He was not the person that you're trying to make him out to be. It's interesting that you're the only person that I've met that David has had a relationship with that has ever made the negative accusatory statements about David's demeanor or his actions as an assault on his character, especially given that he has 2 ex-wives of which neither of them has ever expressed the accusations of his character that you have. In fact, they both showed up to defend his character. One was a relationship of 25 plus years and one of around 13 or so years. They kept in touch after the marriages ended. Of course, you didn't like this and didn't understand that sometimes those relationships are part of who that person is and who they became. Jealousy is never a good trait. Something is amiss with what you're trying to claim about David. I don't understand how you can fear for your life, say he's abusive, yet you will drive from St. Simon's Island to Gainesville, Georgia alone, stay with him alone in the house, allow your son to stay there alone with David instead of staying with you in St. Simon's. It just doesn't make sense to me. You also manipulated him with false texts on occasions to coerce him to come see you. I believe the abuse came from you, Suzanne, not David. But let's be honest. David's family is not the only family that's been damaged by your choices. Your family will never be the same either. My hope today is that you get what you deserve based on the jury's ruling of your choices and your actions. Choices have consequences, and I hope that Judge Brakefield has been able to see through your lies and manipulation. Choices have consequences. It's time for you to receive the maximum penalty for those choices.
Thank you for those very compelling words. Thank you.
Judge, next is Greg Barron.
Welcome. Thank you for being here.
Thank you. I'm David Barron's brother. The second I was born, I had a big brother. We loved playing basketball, football, and baseball so much that our dad put lights up in the backyard so we could play at night. They gave us the means to play. They didn't tell us we had to play. As our years grew quickly and David being presented many awards in both football and basketball, many colleges and universities recruited him. Ultimately, he chose Tennessee. With David at Tennessee, me at UGA, and Cindy going to high school, we were separated from each other for the first time in our lives. The UGA-UT football rivalry has always been intense and remains so this day. However, Mother had a rule and made sure that at the end of the day we were family first. As we grew older, we had children of our own. Life changed a little. We both thought it was important to spend time together with our families, on vacations, boys' trips, and of course UGA Tennessee games. We worked together and celebrated life's joys and tragedies together. I'm fortunate that I had so many fond memories of my brother that I cannot put them all on paper. We would have discussions about March Madness, Major League Baseball, Kentucky Derby, family reunion, Wimbledon, U.S. Open, college and pro football, all things sports. These are things that we used to do together. And this past year, I have not been able to do that with him. Till the March 16th trial, it brought it back on again. So we were going through the football the seasons again. The call came from heaven and called on the morning of March 8th. Didn't seem real. It couldn't be real. When they said that David had been killed, I thought he was in an accident on I-16. I was horrified when I learned that he had been shot and killed by Suzanne. It had to be a bad dream. What happened that night, only two people will ever know. Knowing my brother like I do, I think he had dinner and cleaned up. It was Friday evening. I guess David had a long week at work, traveled, and went to relax. As he fell asleep, he was woken abruptly, went into flight mode, and ran upstairs and locked himself in the bedroom. He was not a confrontational man. My family and I have elected to see the body prior to cremation. The march on the body didn't really go along with the story that was told by the defense. I don't understand where the lacerations came that were on his nose and the marks on his chin, and how his front tooth got chipped. The left side of his face was heavily bruised, what appeared to be a blunt force trauma. Please explain to me how a woman who is described as defenseless was able to move a 6'3" man weighing 240 pounds, had been killed, out of the way of the door to gain access into the locked bedroom. We all know what happened next. Cleanup mode, and the lies began. Regarding your opening statement, Mr. Willis, I wish that you could have known her, but you never will. I'm personally thankful that no one will ever get the treatment that Suzanne gave my brother David. So we've all known the real person that David was, not the make-up version that the defense presented. He was kind, caring, passionate, gracious, unloving family man, not the monster that you have dreamed of. I've heard it said that a heart is not measured by how much you love, but by how much you are loved. David was certainly loved. Thank you.
Thank you for your personal reflections and wise words. Thank you.
Judge, next is Allie Barron.
Welcome. Please state your name.
I'm Alexandra Barron, but I go by Allie.
Thank you.
My name is Allie Barron. I'm Colt's wife and David's daughter-in-law. The last year has been a roller coaster for our family as we experience the lowest low of our life. On March 8th, 2025, our lives changed forever. That morning began normally. I woke up and took our dog Freddie for a walk in our neighborhood. And while I was outside, I received a text from Colt that simply said, "Come home now." The moment I read it, my stomach dropped. I knew something terrible had happened. My anxiety was running through a laundry list of possible scenarios, but I could never have imagined the magnitude of what had occurred. When I got home, Colt was sitting in our family room, tears in his eyes. A rarity for Colt, whose personality lends itself more to joy and playfulness than sadness. Detective Mefford had come to the house to tell us, as the closest family in proximity to the house, that David had been shot by Suzanne during an argument and did not survive. Colt was the first person to hear the news. He had to receive that news by himself, alone. David's son had to hear from a stranger in our living room by himself that his father had been murdered. After that, Colt and I had the unbearable task of calling Evan and Brittany to alert them of the news, and then the four of us began to alert the rest of the family. We had to listen over and over again as the people who loved David experienced the same shock and devastation that we had felt. Our hearts shattered with each phone call because the sentiment was the same. How could this have happened to David? At his core, David was a caretaker. He was a provider. He constantly looked for ways to help the people he loved. After selling his home in Hilton Head, David moved in with Colt and I while figuring out his next chapter. Colt and I had recently bought our home, and we were constantly working on projects around the house. Colt and I would laugh because David never called them your projects. He always called them our projects because he wanted to be involved. Whether it was yard work or hanging light fixtures, taking out the trash, or helping to plan our backyard, David showed his love through showing up. In addition to being a wonderful father to his sons, he loved Evan and Brittany's daughters, his granddaughters, so incredibly much. He was so proud to be a grandfather. So when Colt and I found out we were expecting our first child, while there was so much joy and excitement, a bright light in the darkness of last year, there was also an underpinning of sadness. Our son, Charlie James Barron, will never meet his grandfather. David never got to meet his first grandson. He never got to watch his youngest son become a father. He would have been so proud of Colt, and he would have had the same pride for his now 2 grandsons that he had for his granddaughters. Suzanne took David's life, and in doing she stole far more than one man's future. She robbed my husband and brother-in-law of their father. She robbed my son, my nieces, and my nephew of their pops. She robbed Uncle Greg and Aunt Cindy of their big brother. She robbed countless friends and family members more time, more memories, and more moments with someone who loved deeply and was deeply loved in return. No sentence handed down today will bring David back. That said, we ask the court to recognize the depth of this loss, the magnitude of the harm caused, and the permanent impact Suzanne Mericle's actions have had on every person who loved David. Suzanne's family will continue to see her, hear her voice, and have her be a part of their lives, albeit in a different capacity. Our family is not afforded the same luxury. David deserved more time, our family deserved more time with him, and my son deserved the chance to know his grandfather. Thank you.
Thank you for your very impactful testimony. Thank you.
Allie Barron. Oh, sorry. Brittany Barron.
Welcome. Thank you. Please state your name for the record.
My name is Brittany Barron, and David was my father-in-law. This past year has been one of the most difficult years our family has been through. Losing David has been really tough. He didn't deserve to have his life taken away by such a violent and senseless act. Our family will never be the same from losing him this way. I still can't make sense of why Suzanne couldn't control her actions and had to take his life. What hurts the most is knowing this could have and should have never happened. David was an incredible father, father-in-law, grandfather, brother, uncle, and friend. A person that everyone could count on, who had the biggest heart and was loved so much. Not the monster that Suzanne fabricated and spewed multiple lies about. I've been trying to make sense of it all for a while now, and it still doesn't add up. I'll never forget the feeling I got about Suzanne after she was at our house on Thanksgiving. She was rude and downright mean to David to the point where he would just leave the room when she was speaking negatively about him. That was my first red flag. I don't need to go into details about the second red flag because that was covered in the trial, but any grown woman who texts their partner's son to try to manipulate his thoughts and feelings about his dad has some serious issues. This has impacted us in more ways than anyone can imagine. The countless sleepless nights, the grief, the anxiety, the confusion, the anger, and the sadness are just some of the feelings and emotions we've been going through. The wait for closure and praying that Suzanne gets the maximum sentence for taking David's life has already felt like a lifetime. We are ready to put this chapter behind us and move forward to honor David's memory every chance we get. I would give anything for our family to have more time with him. He should be here. He should be coming over to our house on the weekends, bringing his grandchildren some crazy loud noise toy that he always thought was the funniest thing, and they did too. They loved him. He should be able to hold his grandson and be in awe of the fact that we actually had a boy after 3 girls. He would be talking about it for months after he was born, that he couldn't believe we had a boy. He should be here for all the big life events that have happened over this past year and for the years to come, but he isn't and he won't be. It's just not fair that he was taken away from us. My husband lost his hero, my children lost their pops, and I lost my kind, caregiving father-in-law who treated me like his own daughter. No sentence or amount of time will ever heal the pain of losing David, and we are left with a void in our hearts for the rest of our lives.
Thank you so much for your very impactful testimony. Thank you.
Barron.
Welcome. Thank you so much. Please state your name for the record.
My name is Taylor Cole Barron. I'm the youngest of the 2 sons of James David Barron. I thought about starting this statement off by telling a story about how my dad was a wonderful man, a loving father, an outstanding person, but I'm not going to. I'll keep that story to myself, and I'll cherish it along with all the others I have of my father, because that is all I have left of him. I was told these victim statements are supposed to convey to the court how I have been impacted by what has happened to my father. So here goes. On March 8th, 2025, Suzanne Mericle murdered my father. And every day since, I have felt incomplete. Incomplete in the ability to truly enjoy the things that happen in my life. When I have a big meeting go well at work, my first thought is to call the family, tell them I can't call Dad, because he isn't there to answer. holidays where we are planning a big get-together, I feel a little bit less joyful because he isn't there to help us plan. Betting on the Falcons or the Braves seemed to lose its luster, knowing I'll never be able to go to a game with him again. Any fun new restaurants that Allie and I find taste a bit less good because we can't take him and see him judge the food for the first time. Life feels incomplete. Even the birth of our first child was one of the happiest moments of my life, yet I couldn't feel absolutely thrilled in that moment because I knew my son would never meet his grandfather. This feeling of incompleteness hurts, and I can't make it go away. It's something I'm going to have to learn to live with, but I haven't yet. But past that pain, what hurts the most is seeing what Suzanne's actions have done to my family. My uncle has lost his older brothers, someone he considered his best friends, as you heard earlier, his fishing buddy. He will never be able to call my dad on a random Thursday, pack his bags, and spend a weekend at the lake talking about who knows what. Suzanne took that from my uncle. My aunt has lost her older brother and the rock of a family. As stated, she has a mess and sadly has not been able to be present with us throughout this whole process. But she will never be able to call her older brother, talk for hours about the goings-on in the family and all of our lives. Suzanne took that from her. My mom has lost the father of her 2 sons, and one of the few men she could truly trust to always have her sons back. Suzanne took that from my mom. Our family friends, who are all here, have lost a lifelong friend who they can no longer share and retell old stories with. Undoubtedly, countless Tennessee football stories, I'm sure. Suzanne took that from all of them. And lastly, my brother has lost his father, a man he looked up to for guidance, both personally and professionally. A grandfather to his now 4 children, a role model, and all he wanted to do was make proud. You took that from my brother. She has taken all of these things away from my family, and I want an apology, but I know I will never get one. So I want to ask the court a favor when considering the sentencing and understand who the real victim is, my father and our family. We all heard testimony about trauma, abuse, and PTSD that Suzanne claims to have endured, but in my eyes, as the son of a man who is dead because of her abuse, they are a guise to avoid accountability. Claiming to have endured issues as serious as trauma and PTSD without justification diminishes the experience of the people who truly suffer from those conditions every day. You and the defense team should be ashamed of how you tried to tarnish my father's good name, and I will never forgive you for that. Suzanne murdered my father, and she needs to be held accountable for her actions. And I asked the judge to give her the maximum sentence so that she is never able to hurt another person or family again like she has hurt mine. The maximum sentence so that she can spend the rest of her life thinking about what she has taken from us and how she has left me forever incomplete.
Thank you for your heartfelt testimony. Thank you.
Evan Barron and Judge, may we have the projector?
Welcome. Thank you so much. Please state your name for the record.
Evan Barron. It's okay. It's okay. Where do you want me to start? You want me to start with my son? He was born during a murder trial. And he will never understand why his arrival in this world was in a courtroom seeking justice for his grandfather. What should I tell him? What should I tell his sisters who are 4 years old and 2 years old? You want to know what we've had to do for the past 14 months? We've had to lie to our own children about why Pops isn't here. We've had to lie because the truth is too hard to tell. How do you tell your child that their grandfather was murdered in the middle of the night through a locked door and not expect them to deal with the trauma the rest of their lives like I have to now? Where do you want me to start next? Is it with Brittany, who I had to leave at the hospital after a C-section to go testify about the truth about my dad? While baseless accusations slandered his name, how do you think she really feels? For the past year, the resounding question in our daily lives from others are constantly, what's the latest news on the trial? Don't you think we want to talk about anything more than that? How can you not think that our lives and our relationships should be centered around the positive impacts of raising a family, not haunted by the events of March 8th? Who should we discuss next? You know, the defense team loves posing statements as questions, so who should it be? My employer, my friends, my family? They're all here in this room. Listening online and watching all over the United States, these people that have been here every day of this trial cared about Dad in every chapter of his life because he was a great man. I'm truly not going to spend this whole speech talking about how to defend my dad because I don't think the moment calls for it. We all know who he was. If I felt that he had even tipped off the edge of the pedestal that I hold him on, then I would most certainly would. But there are enough people out there and in here that have heard the lies, the admission of lies, and even the paid for lies. No one believes a single word out of the entirety of the defense team's mouth. Your Honor, this is the hardest part. Is this what a victim's impact statement is supposed to sound like? Is this what it's supposed to be? Should I be waiting for an objection by the defense team for saying how I feel? If this is supposed to be the forum to let you know how the loss of my father has affected me, then how should I phrase it? You already know that I'll never see him again. I'll never hold his finger again. I'll never have French toast again, never hang Christmas lights again, never have him hold my kids again, never hug him again, never hear his laugh again, never get to work with him again, never have him teach me again, never go to a football game again, never hear his voice again. I've sat here listening and watching the graphic and gore of my dad. And I'm supposed to say nothing, express nothing, do nothing, as if he were still here. I know that Dad would be proud of how I've handled this situation. But to be perfectly honest, Your Honor, I hope you're proud of this entire family in your courtroom. This is the level of class that I expect our family to uphold, just as Dad taught us. We have been patient, respectful, and diplomatic. But do you think that's how we really feel right now at this moment? Does anyone know the comments that we've had to hold under our breath or the outcries for the falsities that we've had to keep quiet? I speak on behalf of this family and represent the voices of those wishing to say the things we could for Dad and for all other victims before him of Suzanne's actions. It's been a year of waiting for this moment, and we've had time to be sad, but I look around at the people that are here with us now, and we're just angry. I've grown empty and tired of holding my head high without some relief of letting you know how angry I am that you took my father away from me. There's a litany of things I want to say to those people on that side of the room. The last year and the last 2 months have brought my family immense sadness, immense anger, and above all, a resolve with Colt and I to make sure that our dad's legacy is defined by what it actually is, as opposed to what Suzanne and her team have callously and falsely portrayed it to be. You all should be ashamed of yourselves. You broadcast to the world to see over the course of this trial how you smeared him with the lies. You've tried to embarrass me, embarrass my family, embarrass my business. You took him from us and you've attempted to take down his good name with you, and it's pathetic. I don't care what people say on what a victim's impact statement is supposed to be, and frankly, I don't care what parameters this fits within, but it's how I feel. I've already had to give a eulogy speech for my father once. I'm not going to do it again. I ended that speech by asking if I had said all the words I wanted to say and should say, and I find myself in this situation asking myself the exact same thing. The boiling point of emotion I feel from my family behind me is the one final thing we'd all like to say. Let's hear this sentencing as defined by the rule of law and the sentencing that should be given, so that everyone can start forgetting who she ever was.
Thank you for your very brave, accurate, and personal testimony. Thank you.
There's no other victim in that seat. It's your honor. I was just taking this down, sorry.
Before we turn our attention to the defense, it's a slide button on the, I think. You may have done it. Thank you. Anything else from the state?
Just argument, Judge, after any mitigating evidence.
Okay. Defense, give me an approximation, please.
Judge, we're not going to present mitigation. You've already seen the family. I think you understand what they would tell you. So
Just argument?
We can, and it'll be brief. I can begin it now.
Okay.
Judge, as you know, and I think as you pointed out, there's really two choices the court has here. You can impose a life sentence, which is effectively, that would be the end of Miss Mericle's life. She's 63 years old now. Last time I said 62 and she corrected me. So whatever you impose, it's basically a death sentence in a Georgia prison. The court knows that. You are certainly supposed to consider the gravity of a loss in imposing a sentence, and this is always a strange time for me because you don't need to hear from me about what the goals of sentencing and all those things are. This is what you do every day. But what I will say about the two choices that you have, even though effectively they are the same thing, what I will say is that one of the things, of course, you're to look at is not just the gravity of a loss, which is obviously we have a death, but also the culpability that's been rendered by the verdict. And so respectfully, I would ask the court consider, that this is a conviction for a reckless act as opposed to an intentional one. Georgia law permits sentences like life without parole. You would see them in a case with someone, frankly, with a criminal history that's extensive. You would see it in a case where the commission of the actual act is a vile one. You would see that in a case that really just is not this case. If this is a life without parole case, then what would a life case look like, factually? These folks have suffered. There's no question about that. And they have been respectful and polite and professional. And I think that the Mericle family has done that as well. They're suffering also. They've lost someone also. But I do want to, recognize that I think that the Barron family has been especially polite and proper during this process. And it's not always the case, Judge, as you know. And I think the Mericles have been too. This is a significant loss for them, for sure. But she doesn't have any relevant criminal history for the court to look at. And this is not a life without parole case, respectfully, Judge. And I think the court knows that, and the state too. That's our submission. Thank you.
Judge, state is asking for life with the possibility of parole. I know that might shock defense, might shock Your Honor, but Mr. Willis is right that a life with the possibility of parole sentence is still a life sentence for Ms. Mericle. She is 62 years old. She won't be eligible for parole until she's 92 years old, if she were to live that long. And essentially, Judge, either option Your Honor was given would have resulted in the same thing for Ms. Mericle, and that would be a life sentence in prison. And that is what was important here, is making sure that this defendant never gets out of custody, regardless of what the actual sentence is. And I think that what has been made clear by all the victim impact statements Your Honor heard isn't part of today. The importance of today was to make sure that this defendant spends the rest of her life in prison. The other part of today was finally having the world get to know James David Barron, because we spent 2 weeks having to listen to utter and disgusting lies about Mr. Barron. And this family had to sit there quietly and respectfully and listen while their brother, while their uncle, while their dad was being accused of things that are just so utterly false without being able to say a word about it. Beth and Laura had to get up in court to testify. They wanted to get up in court and testify, and they so desperately wanted to be able to tell the jury about the man that they knew and loved for 10 and 22 years, and all they're allowed to say in trial is he has a reputation for peacefulness. That's as far as this family was allowed to get into about David Barron at trial. And today is finally the day where they were able to have the real David Barron be talked about. And I think that that was just as important as making sure that this defendant spends life in prison for what she did to this family and what she did to David Barron. And I want to make very clear, because of course we're here for the sentencing of Suzanne Mericle for murdering David Barron, and of course she wants to make herself into the victim again. We spent 2 weeks having to listen to her make herself into a victim, only for her to be convicted of murder at her sentencing hearing for murder, and she wants to call herself a victim again. And I want to make very clear, Judge, that Suzanne Mericle is not a victim, she's a murderer. And that's why we're here for sentencing. And I meant every word of what I said in closing arguments about this defendant owing every victim of domestic violence an apology, because it was an absolute disgrace to have to sit there and listen to the lies about rape and sodomy and strangulation and pointing guns, and none of that being true. And it's so frustrating, Judge, as a prosecutor, to hear someone like Suzanne Mericle lie about domestic abuse, because I know how hard it is for real victims of domestic abuse to be believed. I experience it every single day in this job, and it's disgusting, because it's people like her that make it so much more difficult for real victims to be able to get up on that stand and be believed. And Dr. Elkon said almost one of the only things I agreed with her on was how hard it is for domestic violence victims to talk about their abuse, and it's because they don't think anyone's going to believe them. And we wonder why. Because people like her do things like that. And then it makes it 10 times harder for any woman to ever come forward about real abuse because of the disgrace that people like Suzanne Mericle put on domestic violence, and it's disgusting. And I can't imagine, I genuinely can't imagine how difficult it was for this family to have to sit there for 2 weeks and listen to all of the lies about the person they love. And this family is genuinely one of the kindest, most welcoming, loving families I've ever interacted with. And I never got to meet David Barron, obviously, but if the reflection of his family is anything like the kind of person he is, I can't even begin to imagine how difficult it was for them to have to listen to the lies about the person they love from Suzanne Mericle. And that's why today was important, Judge. It wasn't just to make sure that this defendant spends the rest of her life in prison, but it was to make sure that the world gets to know who James David Barron is, and it's nothing like what the defense depicted him as. And so I'm asking Your Honor to sentence her to life with the possibility of parole. Regardless, it's going to be life for this defendant, and that's absolutely what she deserves. And as far as any terms and conditions of probation, if she were to ever be paroled, Judge, the main one just being no contact with anyone in the Barron family. Thank you.
The family and friends of David Barron, I appreciate your class. I appreciate your decorum, and I want to speak to you directly. Clearly, there are no words that this court can offer that will bring your loved one back, and there's no sentence that will change anything. Clearly, the court can never fill the void and the grief left by David's absence. You've been extremely attentive in court. You've been here for the many court dates we've had, not just the 2-week trial. Many of you have viewed the motions as well. And it is clear that you are fighting through staggering and profound grief. And the court recognized that. I've sat on this bench for over 2 weeks. If you include motions, almost 3 weeks. I've reviewed hundreds, if not thousands, of pages from the lawyers in my chambers. I am intimately familiar with this case. I was able to judge the credibility of witnesses, including Ms. Mericle's credibility here in this very courtroom. In doing so, I feel compelled to address the record regarding things that were stated in this courtroom. Everyone has a right to a fair trial. I do want to specifically state that the disparaging and, quite frankly, disgusting comments regarding Mr. David Barron lacked complete credibility. Lacked complete credibility. They serve no purpose other than to tarnish, unfairly tarnish, the memory of a man who is no longer here to defend himself. I take you at your testimony at trial, at here today, as well as the other factors that I've considered, and that I recognize David Barron for the man that he truly was to you, and not the characterization that was manufactured in this courtroom. I hope that the proceedings provide a sense of finality for the legal chapter. I wish you nothing but the best as it relates to your journey of grief and healing. This is not something that we can change, clearly. I know that this is a very compelling and hard case. I understand your emotions. I understand your loss. And it's not fair. It's not fair to you. It's not. That being said, that the court, along with the input from the parties, will fashion an appropriate sentence. For the legal consequences of the incident that we're very well aware of. To the defendant, Suzanne Mericle, the jury has heard and rendered its verdict. I too have listened to every nook and cranny of this case. 2 weeks of trial, arguably a week of motions on and off, thousands of pages. My duty is to impose a sentence that reflects the gravity of the harm that you caused, not Mr. Barron, you caused. These are requirements under the law, and they're requirements under justice. In determining the sentence, I've considered your conduct throughout this trial. You testified, which you have a right to do. I found your testimony to be not credible. I found that you were the primary aggressor in this situation. I found that you had many, many, many off-ramps, and you chose not to take them. Mr. Barron clearly left your proximity and retreated to the upstairs, closed the door. You clearly pursued him. You clearly fired through the door. And I think the state made a very compelling argument to the jury that somehow that the status quo had been your version of events, that you in fact were firing through the door or the lock. But the state, I think, accurately pointed out you very well could have been not aiming for the lock in your jealous rage. That's what it was. I want to be very clear, the efforts to disparage Mr. Barron in this case were noted by this court. I found the comments regarding Mr. Barron to not only be inflammatory, but fundamentally not credible. You had the gun, you fired him, you had, through your profession, you have medical training, no evidence that you rendered aid. There's clear evidence that you then staged the crime scene. Clear evidence that you staged the crime scene. The attempts to shift blame and besmirch Mr. Barron do not weigh in your favor. These unfounded assertions do not mitigate your guilt, but only serve to highlight a lack of genuine remorse for the tragedy that has occurred. every action carries consequences. And in this consequence, these consequences are catastrophic and they're permanent. Appreciate your family's professionalism and decorum as well. They did nothing wrong. They did nothing wrong. But I think Mr. Barron's family said it correctly, that they'll be able to visit you in the Department of Corrections. The Barron family will not be able to visit Mr. Barron. This is a real case. This is not theoretical. This is not an exercise of law school or law. This is the real world. And this is a reckoning. State's recommendation one more time in totality, please.
Judge, as to the felony murder, state was asking for life with the possibility of parole. I think the criminal damage was it max 10? Huh? Merges, and then the reckless 12 months concurrent.
Thank you.
Oh, I forgot about the tampering with evidence. Would also be 12 months concurrent. Sorry.
That's why I asked. Thank you.
Judge, I think the reckless also merges into the.
I can't hear you.
I'm sorry. I think the reckless, there's a criminal damage and a reckless. Those both merge into the felony murder. So it's a felony murder, and then it should be a tampering.
And I agree, Your Honor.
The sentence will so reflect. Anything else?
Not from the state judge.
I think we're all aware, and I think that both sides have made this point. At your age, by law, you can take your age, we're at 62 or 63, and add 30, 93. I think in the best of circumstances, that's a long life lived. I'll make no comment one way or the other. This is certainly a case that could be argued both ways. Coming in today, I was anticipating not only the domestic violence issue that was going to be brought up, but obviously contemplating what the sides, and obviously you never know, but contemplating what the sides would or would not ask for. I agree with the parties as it relates to the lack of prior criminal history. That other factors are not present in this case. I completely understand that. I also agree with the general concept that life or life without parole, whatever it may be, is essentially a life sentence. And for the family's sake, I do want to be clear that I do believe that this is a case that warrants Ms. Mericle never leaving the Department of Corrections. So for whatever comfort that is, and I'm not going to get into what the lawyers think or don't think. I think that there may be a legal issue if I were to impose life without the possibility of parole. I'm making no assumptions of what the lawyers, but I think that's why the state's asking for what they're asking for. So I will side with the state, and I will impose their requested sentence. That being said, that the very likelihood is that this is her being imprisoned for the rest of her natural life. So I will concur with the state in their recommendation, which is the same as the defense without the domestic violence mitigating, which I've ruled against. It's judgment of the court that you are committed to the Department of Corrections for the remainder of your natural life. I hereby remand the defendant in the custody of the Sheriff's Department and the Georgia Department of Corrections. We are adjourned.